removing or committed an act that placed the person in reasonable apprehension or fear of immediately receiving a violent injury. Is that tailored to the McCord's charges as well?
It should be as well.
Okay, well, let's check. Okay, it doesn't say, so you've indicted the McCords by pointing a firearm at, toward, in the direction of Christopher McCord, said firearm being a deadly weapon. It doesn't say attempted to cause a violent injury to the person. It says pointed a gun at them. Okay.
In the past, that's usually how they defined assault. It's an attempt to, an attempt of a violent injury on to whoever, based on the fact that a firearm is a deadly weapon as a matter of law.
Okay. Any objection?
No.
Okay.
Very vague. Very charged. It's crazy.
Yeah. Okay, any other topics you wanted to bring up?
And then for continuity purposes, when we go into the elements, it's A, B, C, and D for like felony murder and those things. I'm sorry, it's 1, 2, and 3. But then when we get down to the criminal street gang, the state must prove, it's just one blurb of a paragraph. Again, that's just my.
Give us the direction where you are. Give us the direction where you are on this page.
I think he's saying in general, there's bulleted elements, and when we rewrote the gang charges last night, we took out the bullets.
10 is where I am.
Okay, I'm inclined to leave it that way.
Okay.
I get what you're saying, and normally I would agree with you, but we spent a lot of time on that.
That's fine, Your Honor.
Thank you.
Your Honor, when you're ready, on behalf of Mr. Conley, I have one.
Yes, sir.
I do object to the, on page 10, when it comes to the street gang, when it comes to counts 9 and 12. Once again, in count A, there needs to be a nexus, and the jury charges has that word, that sentence in there. But when it comes to on the next page, violation of subsection E, you do not have that. And once again, I disagree. I agree that under the statute, the way subsection E is written, that it does not require a nexus. Case law says that. However, at the point where the state changes the charge that's been indicted, and they're not following the statute, they actually included in subsection E what the court said or why the court said subsection A requires a nexus. They brought themselves that added burden, that added step of the nexus for counts, I believe it's 9 and 12. So I do object to the way this is written. I think the nexus wording needs to be in there for at least those two charges because of the way the state particularly indicted.
Would you scroll up to subpart E, the definition in E? Okay, I'm going to note your objection for the record. And I did modify the charge in part, but I'm going to leave it as is. I know, it's fine. Okay. Any other charges that we need to call to attention? Okay. All right, and who's going to be closing on behalf of the state? Are you splitting that?
Yes, Your Honor. I'm going to open close, and Ms. Young is going to close.
Okay, and Ms. Broderick, okay. As soon as we have Ms. Broderick, you can bring the jury in. Thank you.
Thank you. I didn't know.
Okay, once again, I'll remind the audience, closing arguments can be dramatic and emotional. It's very important not to have any audible or visible reactions in front of the jury, and if you find that you're getting upset and need to leave, it's fine to stand up and walk out. Okay, we're ready.
I know this is the only time I need positive reinforcement. I find this is the only time in my life I need positive reinforcement. Positive. No. I mean, I'll be doing that. Dramatic. What do you like to do? I've seen you close a few times.
And please, everyone, if you have your device, please make sure it's silenced.
Is it showing? Okay.
It is.
My God, it might work. Oh, okay.
And is your screen fixed today?
Yes.
Okay.
For now.
I thought we only had haunted screens in my courtroom. I didn't know they were down here too. Screen, yeah. In my courtroom, it's microphones.
All right, to the jury. All right, jury, they found the court.
Good morning, members of the jury. All the evidence is closed, and we're now getting ready to hear closing arguments of the parties. I'm going to remind you again that statements made by attorneys are not evidence, and you'll rely on your memories as to what the evidence is. There are going to be 3 arguments. The state is going to open. Then the defense will have an opportunity, and the state will get to argue again because they have the burden of proof. If at any point between the arguments you need a break, you can just let me know. I'll check in with you again because the arguments can be long. And we're planning to provide lunch for you today to try to keep things moving. Okay?
The trusty old technology work. Start with talking to you about what this case is not about. This case is not about the action told you and sat here and explained in great detail every parent's worst nightmare. The most unnatural thing in life. She sat before each and every one of you and explained to you all the facts and the circumstances that she experienced in that absolutely terrible moment in her life as she sat before each and every one of you last week. When Charmaine was testifying, she talked to you about how much Secoriea loved her brothers, how much she loved playing with her cousins. And she said something while she was testifying that caught my attention, that I'll never forget. She said she just loved to love. She just loved to love. And this defendant, on July 4th, took that love away from this world, took that love away from Charmaine. But as she testified, she talked to you about the last moments of Secorea's life. And I hadn't caught it, I hadn't heard it, until she sat before all of us and explained to each and every one of us what she felt, what she remembered, and what happened in that car on July 4th of 2020. But when she was testifying, when she was talking to each and every one of you about the last moments of little Secoria's life, she said she didn't talk. She just looked into her mother's eyes. She just caught her eyes and gazed into her mother's eyes. In the last moments of her life, Charmaine was describing Secoriea still trying to provide that love, that comfort to her mother. And this defendant on July 4th of 2020 shut that light off. Made it so the joy that Secorea's family felt every single moment that they were around her was gone. But Charmaine made very clear that Secorea's memory will live on, that they created a scholarship at Spelman in her name, and that he may have taken her from this world, but he can't take her memory. Her light will always shine on the things that were most important to her. And that was clear from the testimony of Charmaine. That was her family. Now, I want to talk to you over the next 25, 30 minutes about some of the law that the judge is going to explain to you at the end of the trial. And the law that you're going to apply to all the facts and all the evidence that you've heard this week and feels like more than a week ago. I can at least say it for me. But I want to start with talking to you about your duty, a juror's duty. And your duty is just plain and simple. Be a fair, impartial juror, honestly seeking the truth. You're not to seek doubt. You're here to weigh the facts and weigh the evidence and make a decision. It's kind of what we talked to you when we started the process. It's exactly what we did. We asked you questions, you gave us answers. We asked you some more prying questions, and you gave us answers. And that's how we were able to determine that you, ladies and gentlemen, were the right people for this job. That you could listen to all the facts, that you could listen to all the evidence, and be fair and impartial, and seek the truth of what happened on July 4th of 2020 when Secoriea Turner was killed. Now, again, it's to seek the truth, you're to follow the law that the judge is going to give to you, and you're to deliberate. And we say that, the deliberate part, I know it sounds incredibly obvious, but there have been times in the past where jurors forget that they're supposed to deliberate, and one or two may decide that they don't want to partake in the proceedings. So we just tell you that so you're aware that that does happen, and I don't think it will, but if it ever does, that's something you just bring to the court's attention, and it'll be addressed. You just seek the truth according to the evidence. You are to determine the facts of the case based on what was presented to you over the course of the last 2 weeks. All of the evidence in the form of photographs, videos, testimony that you heard from the witnesses here at this witness stand, Up in the courtroom, it sounds like the bigger jury room, that first day that we started trial. Now, what you're not to consider passion. You're not to consider public opinion. Whether you are unhappy or like the performance of the police here or in your past. Public feeling and sentiment as it relates to social issues that we've heard a little bit about over the last 2 weeks. Sympathy for the defendant, sympathy for Secoria's family. Whether you disagree with the law, conjecture, you are not to consider penalty or punishment. That's for the judge. And any prejudice you may have. You leave that outside of the deliberation room. And what you are to consider and what you are to use as tools to apply to the evidence and the facts and the testimony that you've heard is obviously the law, the testimony of all the witnesses that you heard and your recollection and reviewing your notes, admitted evidence that you will receive at the end of this trial, the elements of the crime, which you'll learn about here shortly from the parties and from the judge, expert witness testimony, physical evidence, and as we all talked about on Monday 2 weeks ago, your common sense and your life experience. So to use all of that when you are cycling through and remembering and looking through your notes about the facts and the evidence and the testimony that's come out over the course of this trial. Now, you heard a little bit about this at the beginning of the trial, about whether you can hold the state to its burden of proof. And that burden of proof, it rests with the state. It never leaves the table. The burden of proof is always with this side. The burden is for the state to prove beyond a reasonable doubt each and every material allegation, each and every element of every crime in the indictment that you painstakingly heard me read the first day we started the trial. Now, the judge is going to talk to you about each and every defendant. This defendant, when we started this trial, had a presumption of innocence. Every defendant who exercises his constitutional right to a trial has this presumption of innocence. I like to kind of compare it to a cloak or a jacket. So he walked in on the day we started trial with a suit coat on, with the presumption of innocence, and as the facts and the testimony unfolded, as witnesses testified, as the video from every angle was shown to Detective Shepard, it started getting warmer in this room, and it was pretty warm throughout this trial. But as the evidence and the facts and the testimony continued to come out, that cloak came off. That cloak of innocence went goodbye. Because the state proved, when we rested beyond a reasonable doubt, that this defendant is guilty of each and every count in this indictment. Now, you're going to hear a lot about reasonable doubt, what it means, and a bunch of lawyer jargon. We lawyers tend to use words that should be easy to understand, then we take them and garble them and make them pretty complicated. So reasonable doubt means just what it says, reasonable. It's based on your common sense, your reason, your life experience. It doesn't mean an arbitrary or vague doubt. It's a doubt in which you can give a reason. It's a doubt in which is reasonable. Now, the state's not required to prove the guilt of the defendant beyond all doubt, beyond a mathematical certainty. There's no equation involved, because the only equation that's involved in this trial, any way that you put it, if you do 2 plus 2, 4 plus 4, whatever it may be, they all equal -1. They all equal -1. Because no matter how you look at it, how you put the facts and the circumstances together, Secoria's gone. She's not coming back. That's the equation that's important in this trial. Reasonable doubt is the doubt of a fair-minded, impartial juror honestly seeking the truth. Again, you're not to seek doubt. What does that mean? Apply your life experiences, apply your common sense to what you heard over the last 2 weeks, and that's how you come to your decision. That's what you do back in the deliberation room. The only difference is once the trial ends, once the judge finishes the charge, you guys are in the driver's seat. You don't have to wait on us. There's no breaks because of any conversations that the attorneys have to have, or any sidebars with the judge. You guys are in control, and you guys get to apply all of your life experiences to everything you've heard over the course of this trial. The judge is going to talk to you about the different types of evidence, but there's direct and circumstantial evidence. And she's going to explain to you what each one of those is. It's fairly obvious. Direct evidence is evidence that points immediately to a question at issue. So it's evidence that's tangible. It's photographs. It's the videos. It's documents. It's testimony that you heard from witnesses as to what they saw, what they heard, what they remembered seeing and hearing on July 4th, 2020. She's also going to talk to you about circumstantial evidence. But as it relates to direct evidence, again, not the 911 calls that you've heard, things of that nature. What Omar and Ms. Charmaine were called, and how they were able to remember and talk to you about the 911 call that was made that night. And the people they remember seeing surrounding them as they passed the barricades. Circumstantial evidence is proof of facts or circumstances by direct evidence, which you may infer other related or connected facts that are reasonable and justified, again, in light of your life experience. Now, I like to provide an example I think we all have experienced in life, an everyday experience. So, when I'm one of 4 children, I have a twin sister, I have a brother who is 16 months younger than me, and then I had a brother who was 6 years younger than me. So my mom had her hands full throughout the years that she was raising us. Now, before my youngest brother was born, it was almost as if my sister, my brother, and myself were triplets, because we were very close in age, and we were pretty wild. So we injured ourselves quite often. And so we were either in the ER, doctor's office, whatever it may be, with a broken arm, busted leg, busted lip, something that needed to be patched up. Now, if you use what we just talked about, direct and circumstantial evidence, circumstantially, you don't know anything about the facts and circumstances. You see my mom bringing all 3 of her children to the hospital or to the doctors injured. And you may draw some inferences based on what you just see, not knowing any of the context or the details. Now, what's interesting is as the doctors would speak to each one of us children, as they would treat each one of our injuries, what they were able to see directly from speaking to us, the injured parties, and my mom, who unfortunately for her was an eyewitness to most of our injuries, was that we were crazy 3 kids who couldn't sit still and liked to have fun. And so that's how I like to explain direct and circumstantial evidence and how you apply it and use it. And what the doctors would say beyond a reasonable doubt after we leave, after each visit, that we be back. And that my mom had the patience of saying. So that's how you use your life experiences to use direct evidence and circumstantial evidence to come to a conclusion, like exactly what you're going to have to do when you were looking at the facts and the testimony of this case. The judge is also going to tell you that the testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there's no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. Now, this is a great example of this. You heard from Mr. Christopher McCord. He testified about his experiences in the community, how long he had lived in that area near Pryor and University, and his experience on July 4th when he approached the barricade, and what he remembered, and how he remembered that 2 people specifically, one had a shotgun, another had a long rifle, and pointed it in his face to him and his wife as they attempted to pass through. Now they were able to turn around after Mr. McCord had an exchange of words with who he later identified as the defendant, Detective Shepard, when he told Detective Shepard that the individual he saw on the news conference was the person who pointed that AR-style rifle at his face when he first encountered the barricades. And Mr. McCord's testimony, Mr. McCord's recollection, is further corroborated by the video evidence that you saw painstakingly over and over and over again over the course of this trial. You see this defendant in his very distinctive clothes with his AR-style rifle doing some sort of, looked like military move, pointing a weapon in the direction of both Mr. and Mrs. McCord, looking as if he's about to engage their vehicle with his AR-15. You are also going to hear about how you're to judge the credibility of witnesses like Mr. McCord, how you're to judge the credibility of Detective Shepard, and how Detective Shepard explained to you the process in which he took and how he worked backwards after he got all of the video tracking the defendant because of his distinctive clothing in each one of the videos, in each one of the angles, in order to place him exactly where he told you and where this defendant is at the time that the Jeep Secoriea is traveling and passes the barricade, at the time that Secoriea is shot in the back. The judge is also going to talk to you about statements that you heard previously. It's not a secret. This case is not a case that occurred yesterday. It's a case that occurred in July of 2020. As your common sense will tell you, memories fade. That's why things are recorded and things of that nature. That's why you heard about reports and prior statements that were made and talked about during the testimony of this case. Now, the judge is also going to talk to you about identification. And identity is a question of fact for you, ladies and gentlemen, to determine. Your determination of identity is dependent upon the credibility of witnesses or witnesses offered for this purpose. You should consider all the factors previously charged about credibility, which you'll hear about again from the judge at the end of the trial, and the factors you would apply, and the ones we just talked about. And a great way to kind of boil this down is the books when we were kids, the Where's Waldo book. And, at first, you'd flip through each page, you'd look for wherever Waldo was, but once you found him, you couldn't find him again. That's exactly what we have here. And that's exactly what Detective Shepard explained to you, and that's exactly what you saw as it relates to this defendant's distinctive clothing. And once you know where he is, what he's by, and when he's at the barricade, you can then use the contextual clues that you've learned from your previous experience of seeing where this defendant is, what he's wearing, and how he looks. And then you never lose him. And that's exactly what Detective Shepard described. And this is exactly who Detective Shepard first saw in the Martyr video, in photographs during the day prior to being seen in the Martyr video, in the exact same clothing, with the exact same satchel, the exact same gun, same photos, bolo. The defendant's photo from his license, and the defendant on the day that he did his press conference, and provided you the statements that he did along with his counsel that referenced his recollection based on not knowing what was eventually found on the video. That statement was made by this defendant and his counsel before he knew there was more than bolo photos from a Martyr video, before he knew that Detective Shepard had been able to pull video footage from the all-package liquor store, that he was able to pull footage from the BP gas station, and that he was able to pull footage from the 2 cameras at the warehouse, and that he was able to track the defendant's every move as that car approached the barricade. So when he did this press conference, the distinctive outfit was nothing to him. It was just a gang advertisement for the pirate gangs. He didn't know that Detective Shepard was able to track that red shirt with this distinctive red lettering in each one of the cameras that he described to you. Now, I want to talk to you about parties to a crime. And we referenced aspects or parts of this jury body or jury selection. We're going to talk to you about this. And the judge is going to tell you that every party to a crime may be charged with and convicted of the commission of the crime. A person is a party to a crime only if that person directly commits the crime, intentionally helps the commission of the crime, intentionally advises, encourages, hires, counsels, or procures another to commit the crime. The judge is also going to tell you about, and you heard when we read the indictment, about Jerrion and McKinney. And the reason this slide is up here, and the reason this chart is given to you, is that you're not to consider Mr. McKinney and his case and what's going on with it. You're just to consider the evidence that you heard and his role that he played and how he worked in conjunction with this defendant. That's what's important to your analysis, ladies and gentlemen. That's what is important as you view and go through the evidence and remember the testimony. It's the role that Mr. McKinney played and how he worked with this defendant. You're not to consider or worry about what's going on with his case, because his case is for another day and for another jury. Now, you also heard from Detective Shepard about parties to a crime, and he gave you an example involving a bank robbery. And I'm sure each one of you remember the example he gave and how he gave it, and the importance it plays in providing an example as to basically the actions of one or the actions of all as you work together. And the way I like to think about it and describe is kind of a team sports example. My brother played football at Wake Forest back when the one season that they were pretty good. They'd gone to the Orange Bowl, and I went to every one of those games. It was a great experience to watch somebody who you care about succeed on such a high level. And why it's something that I am able to utilize when I'm talking to people like you, ladies and gentlemen, is because in a sport like football, it's every player has a role. You've got the quarterback, you've got the defense, the offense, things of that nature. And no matter if the quarterback throws an 80-yard pass and a touchdown occurs, 7 points go on the board, it's not 7 points for the quarterback. It's not 7 points for the person who caught it. It's 7 points for the team. Here it was the Demon Deacons. So everyone has to play a role in order for the end goal to occur. And when the end goal occurs or a failure occurs, the entire team accepts the goal or gets to succeed and celebrate or not, but together. It's not just the quarterback getting the 7 points or the running back getting the 7 points. It's the whole team, or it's the whole team losing. So everyone plays a role in order to get to the end process, in order to get to the win, or in order to incur the loss. The judge is also going to talk to you about conspiracy, and it's very much kind of like parties to a crime. So conspiracy means an agreement between at least two people to commit an unlawful act. That agreement does not have to be something where you shake hands and a verbal of nature. It can be shown through conduct and presence of the parties involved. The presence, companionship, and conduct before and after the commission of the alleged offense may be considered in your determining whether circumstances arise to the point where you think a conspiracy exists. And what does that mean? It basically just means that the things that you do before, during, and after, the actions that people see, the fact that this defendant and the members of his gang and friends showed up to the barricades, worked in tandem as a team to prevent citizens like you, ladies and gentlemen, from traveling down University and Pryor. And at times when people didn't submit to that authority, when people asserted their own independence on July 4th, they were met with threats and they were met with violence, and Secoriea was met with the ultimate violence. She paid the ultimate price for the lack of submission to their authority. Like I said, the agreement may be expressed, meaning it can be written, things of that nature, but it also can be an unspoken understanding. It can be a group of people, as we heard yesterday, at times all showed up for the same did similar, the same actions in the sense that they didn't have an agreement where they wrote down on a piece of paper they were going to not let people pass through the barricade. But the unspoken understanding was the fact that they all participated and didn't let people go through the barricades, and there were consequences that they all worked together to, I guess, provide to individuals who didn't assert to their authority, to individuals who didn't submit to their dominance. What the evidence showed during the last 2 weeks was that this defendant and his other co-conspirators, named and unnamed, known and unknown, through their actions, their words, both had an agreement to participate in a legal barricade. When they did that, they refused to allow citizens to travel through a university in Pryor. And if anyone attempted to disrespect them, if anyone attempted to travel through those barricades, they were met with violence. That's what we saw. That's what the defendant's actions are boiled down to on July 4th of 2020. How do we know there were 2 or more conspirators? You've got video evidence. You've got video evidence from angles everywhere. You've got 3, 4, 5 people at the barricade at the time. You've got the defendant shooting with 3 of the people he had been guarding the barricade with through the evening of July 4th. You've got the examples of the agreement with the aggravated assault that was incurred on the McCourts. You've got McCourts leaving. You've got 1, 2, Mr. McKinney, 3 individuals with guns, all working in tandem, all following the fleeing McCourts. All an example of an agreement by 2 or more conspirators. What the agreement does not require is, as we've talked about, written, or it doesn't have to be written or oral. It doesn't have to be anything that necessarily has to be said. You don't have to write a contract with details. It can just be an understood thing where, like this situation, you stand at a barricade with your AR and you don't let people through. And you commit acts of violence when they don't submit. And the judge is going to talk to you about, and you're going to hear about the elements of all the crimes that you've heard in the indictment that were read to you at the beginning of this trial. She's going to talk to you about count 1, murder. She's going to talk to you about counts 2 and 3, which are felony murders, and the predicate offenses or acts for each one of those felony murders, that being the aggravated assault, the deadly weapon on Secoriea Turner, and then count 7, which is the criminal damage to property in first degree for the shooting of the Jeep that Secoriea was riding in when she was killed. You're going to hear about the aggravated assaults in counts 5 and 6 that Omar Ivory and Charmaine Turner experienced when their car was fired on, the same car they were traveling with little Secoriea. You're going to hear about count 8, possession of a firearm during the commission of a felony. And you're going to hear about counts 9, 10, 11, and 12, and then 17, 18, 19, and 20 about those specific charges involving participation in criminal street gang activity and the different subsections that the judge will read and tell you the elements as it relates to each one of those charges. Then you're going to hear about counts 13 and 14, which we talked a little bit about today, about the aggravated assault that the McCourts experienced when they first encountered the barricade with guns being pointed and threatened because of the disrespect they were showing for beginning to travel through the barricade. And then the aggravated assaults that you actually saw that were committed on the video by this defendant and Jerrion McKinney when they were pointing their firearms at both Mr. and Mrs. McCourt as they drove away. And the judge is going to tell you that with every one of the crimes in this indictment, specifically murder, intent is an essential element of any crime that must be proved by the state beyond a reasonable doubt. You may be shown in many ways provided before you, ladies and gentlemen, by facts and evidence from the witness stand, from physical pieces of evidence that are entered during the course of the trial from different witnesses, and you may infer from the proven circumstances or by acts and conduct, or it may be in your discretion infer what is the natural and necessary consequence of the act. So what does that mean? the natural and necessary consequence of pointing your AR-style rifle and pulling the trigger at least 8 times as a car, in this instance, a Jeep, where Secoriea was seated in the back, just playing on her phone, watching TikTok, that when you fire that weapon, that high velocity rifle into that vehicle, the natural and necessary consequence, it's going to hit somebody. It's going to hit the driver. In this instance, it could hit Charmaine, and in this instance, it did hit Secoriea Turner. And the natural and necessary consequence of getting shot with an AR-style rifle is death, is murder. It does not mean the intention to violate the law or to violate a criminal statute. It means simply the intention to commit the act that is prohibited by the statute. The state must prove that this defendant caused the death of another person, here, 8-year-old Secoriea Turner, unlawfully and with malice aforethought. The judge is going to talk to you about what that very antiquated term malice aforethought means. Malice is not necessarily ill will or hatred. Rather, it's the unlawful intent to kill. You may find malice in the circumstances show that this defendant acted with deliberate intention to unlawfully take the life of another person, to deliberately fire his high-velocity rifle into a car that's carrying 3 people, that led to the death of Secoriea Turner. The judge is also going to tell you that malice can be shown where there does not appear to be significant provocation, and all the circumstances show what is called an abandoned and malignant heart. What does that mean? It means you have no regard for human life. And that's exactly what you saw in this instance. When you take your gun and fire your rifle at least 8 times at an unsuspecting car, that's what we call an abandoned and malignant heart. That's when you take someone's car, throw it on the ground, and you stomp on it. But that's all it is. It's when you have absolutely no regard for human life, when you have absolutely no regard for a little girl who's just trying to get home to play with her cousins. The judge is going to tell you that murder, the state doesn't have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how brief the malicious intent existed with no specific length of time. The judge is going to tell you to form an instant, in a moment, that if malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do so, that's enough for the killing to be murder here in the state of Georgia. The state does not have to prove motive. I would submit to you, ladies and gentlemen, there was motive. The motive was clear. It was the defendant and his members of his illegal barricade militia felt disrespected, and because of that disrespect, they just opened fire on the vehicle that Secoriea was riding home in. The judge is also going to tell you and give you the elements of felony murder. And felony murder, you can find it in counts 2 and 3. And with felony murder, there's always going to be a predicate act. In this instance, the predicate acts are aggravated assault and criminal damage to property in the first degree. And the judge is going to tell you, unlike malice murder, felony murder, no proof of malice is required. You don't have to show you express or implied malice, we just talked about. There's no intent to cause the death. That's not required. What's required is that if the death occurred while the defendant was engaged in the performance of a felony act, an aggravated assault, criminal damage to property in the first degree, shooting into that vehicle, and someone dies as a result of it, that's felony murder. Again, that's the natural and necessary and expected consequences of an act, such as the one that this defendant committed on July 4th of 2020. And again, the predicate acts are aggravated assault and criminal damage to property. The judge is going to tell you about what aggravated assault with a deadly weapon is. Pretty straightforward, it's self-explanatory for once. It's an assault with a deadly weapon. The judge is going to say that as a matter of law, a firearm, a rifle, a handgun, things of that nature are considered a deadly weapon as a matter of law. To constitute an assault, actual injury need not be shown. The evidence only must show that the defendant attempted to commit a violent injury to the person of another. As it relates to little Secoriea Turner, her mother Charmaine, and Omar Ivory, we have both. We obviously have a devastating injury caused to Secoriea that ended her life. But then you have no injury, but obviously the intent to provide a violent injury was there and provided as it relates to both Charmaine and Mr. Ivory. They just got lucky. They survived. You're also going to see two counts, counts 13 and count 14, with the very same charges, very same elements as it relates to the McCords, Samantha, and Christopher. And as you saw on the video, after that distinct clothing was seen in the Martin video, and as Detective Shepard described, black do-rag, twist, red shirt, white lettering on the shirt, AR style, firearm, black satchel, light pants, and a light-skinned individual. 8 identifying characteristics that he looked for painstakingly in every video, in every second, every footage he watched. Now, the judge is going to tell you about criminal damage to property in the first degree. It's exactly what it sounds like it is. It's knowingly and without authority, interfering with somebody else's property, and while doing so, you do it in such a manner that you endanger human life. Pretty straightforward. Take a AR rifle, fire it into a Jeep, in this instance, endangering the lives of everybody in that vehicle and ending the life of Secoriea Turner's. Shooting that vehicle all on the driver's side 8 times. 2 to the driver's side back. The judge is also going to talk to you about the possession of a firearm and the commission of a felony. Again, not a mystery. The state must prove that the defendant had a firearm on his person or within arm's reach of his person while committing. The judge is going to tell you at least one of the following acts we talked about here today: murder, felony murder, aggravated assault with a deadly weapon, as it relates to both Ms. Turner and Mr. Ivory, and then McCords, and then criminal damage to property in the first degree, where the defendant was using his rifle as he described in his video that you saw during the testimony of Special Agent Coleman in a berserk way as he took that gun and fired it 8 times at Charmaine's Jeep. And here is just some photographs of the defendant with his firearm as he's committing the aggravated assaults against both Mr. and Mrs. McCord. Showing the defendant in the exact same clothing that Detective Shepard described that you just saw in a different angle. Still holding that firearm during the felonies just described. And the judge is going to talk to you about the remaining counts, counts 9, 10, 11, and 12, and then 17, 18, 19, and 20, which involve the violation of the Street Gang and Terrorism Prevention Act, the gang counts, and the indictment. The judge is going to talk to you about each one of the subsections, subsection A, B, and then subsection E. You're going to hear about the elements of each one of these counts as it relates to what's required for subsection A, what's required for subsection B, and what's required for subsection E. The judge is going to define and give you information as it relates to participation in criminal street gang activity and what that means. The judge is going to tell you that person commits the offense of the violation of the Georgia Street Gang Terrorism and Prevention Act, the gang counts, when that person, while associated with a criminal street gang, the Pyrie Bloods, commits a crime that constitutes criminal gang activity. What's criminal gang activity? In this case, the judge is going to tell you it means commission, attempted commission, or conspiracy to commit, which we talked about, any offense that involves violence, aggravated assaults, for example, murder, felony murder, and the possession of a weapon or use of a weapon. And here, like we just talked about, murder, property in the first degree and possession of a firearm during the commission of those same certain felonies. The judge is going to tell you, you are to consider criminal gang activity. She's going to talk to you about the tools that you are to utilize when you go back to, during deliberations and how you are to consider how criminal gang activity can be shown. The judge is going to tell you that the commission of any offense that would constitute criminal gang activity by any member or associate of an alleged criminal street gang, here at the Pyru Bloods, and that you are able to make that determination as it relates to whether there's the existence of a criminal street gang and criminal street gang activity by looking at those offenses, by utilizing the information that was provided by Special Agent Coleman, the information that was provided by this defendant and his Instagram, as it relates to his membership and association with the Pyru Bloods. The judge is going to tell you for the subsection A counts 9 and 17, that the state must show beyond a reasonable doubt the existence of a criminal street gang, here the Pyru Bloods, that the defendant is associated with that criminal street gang, the Pyru Bloods. He told you that in his own words, and what Special Agent Coleman described as his autobiography, outlining his gang membership not only in the Pyru Bloods, but in the G-Shine sect of the Bloods prior to that. And then the judge is going to talk to you about that the defendant committed or participated in criminal gang activity, and that the state showed a nexus or connection between the crimes that were committed, the aggravated assault, the murder, the felony murder, and the interest or furthering the interests of that gang. And here, as Detective Coleman talked about during his testimony, was clear that the acts that were committed, the acts that killed Secoriea Turner, were all due to the disrespect that was shown to this defendant and the members of his gang. That they didn't stop, they didn't bow down, they didn't submit to the authority of this defendant on July 4th, and they paid the consequences for it. It's as simple as that. She's going to tell you for counts 10 and 18, which is subsection B of our Gang Act, that the state must show the existence, again, of a criminal street gang, that the defendant is, again, associated with that criminal street gang, and that the defendant participated, again, in criminal gang activity, and he did all of that in order to maintain and increase his status or position in the gang. And you heard from Special Agent Coleman about how one increases and maintains the status or position in their gang. It's not about rank, he told you. It's not about things of that nature. It's about doing things in a highly visible manner. And because of that, you gain respect. You put in the work, and people watch you put in the work, the way Special Agent Coleman described it, which is exactly what happened here. This was, as we heard from Ms. Salloway yesterday, this was a crowded area. It had been crowded since the death of Rayshard Brooks. I think she said she started going to that location at University and Pryor the very next day on June 13th. And then from June 13th on, it was her core. I think she said 10 to 20 people. And then every day, hundreds of other people showed up to protest and support the movement as it relates to the social injustice, as she described, for George Floyd and Rayshard Brooks. And at some point, this defendant took that movement over. That on July 4th of 2020, this defendant and the members of his armed militia took that movement over and turned it into a deadly celebration on the 4th of July. It's as simple as that. And did that in front of all of those people, as you saw in the video, and as was described by Detective Shepard, as was described during Special Agent Coleman's testimony. And then lastly, counts 11, 12, 19, and 20, which are your subsection E of our Criminal Street Gang Act statute. Again, the existence of a criminal street gang, encouraged another to participate in criminal gang activity, and that the defendant was at the time an associate of the criminal street gang here, the Pirate Blood. The judge is going to tell you that as it relates to the term participate, that it means to take part in something, to share in something. Clearly, they were all taking part and sharing in the blocking of this road, the prevention of citizens being able to travel freely about the area of Pryor and University. It's not complicated as it relates to the elements of this crime because of the obvious nature and the in-your-face ways that this defendant and the members of his wannabe militia acted on July 4th of 2020, acted unknowingly that it was being reported by the local businesses and areas around, thinking that their dominance wasn't going to be collected by video evidence, that they would be able to continue to dominate that area without any consequence, without Detective Shepard being able to go through the hours of footage to find his distinctive clothing. The judge is going to talk to you also about what a criminal street gang is here, as you learned through Special Agent Coleman. The existence of a criminal street gang may be established by evidence of a common name, the Pirate Blood, the Bloods, and the signs and symbols, tattoos, the graffiti, and things of that nature, attire that gang utilizes and advertises with to get their customs and behaviors out to the members of the public, and here out to the people at Pryor University and the fear that they wanted to spread that evening. Some examples that Special Agent Coleman described as it relates specifically to the Pirate Bloods. Ad nauseam, he talked about the red color, the red attire, red tattoos, things of that nature, the 5-point star, and the red accents in the tattoo. The Elm Street reference, the 700 block reference, the 365, the anniversary for the members of that gang, red bandanas. And he described the distinctive characteristics of not Bloods, but the Pirate Bloods, that their distinguishing and distinctive characteristic is their violent ways in which they spread their dominance, in which they assert their authority, which is exactly what you saw on July 4th of 2020. Nothing different, nothing unexpected. And I was thinking about an example as it relates to the defendant's tattoos. You heard on the cross of Special Agent Coleman about the ice skate tattoo that was across the defendant's hand. And you heard a number of questions from defense counsel, Mr. Hoover, about this ice skate and what it means and its company and things of that nature. And all of that may be very true. And you heard Mr. Hoover talk about some characteristics that I think he said he had a 5-point star tattooed somewhere on his body, and then he talked about his family from Chicago, and I couldn't remember the last thing that he said as it relates to trying to compare the defendant's ice skate to the use of ice skate on his hand, and then the use of it along with other gang characteristics in his Instagram. But I was thinking, Mr. Hoover's exactly right. So the fact that he has a 5-point star, that he's from Chicago, I think he said his dad's name is, I can't remember, or his last name is Hoover. That doesn't make him a gang member because he's got a 5-point star and he's from Chicago, and the last characteristic he said, because he doesn't incorporate that, or he doesn't use that in conjunction with gang activity. He doesn't use that to advertise gang membership like this defendant did. He would write ice skate with mob. He'd write ice skate and then put, Elm Street block 700. I mean, that's the point. I have a 5 on my wrist. It means nothing but 5. But if I was to put that 5 on my wrist, up on a photograph next to Elm Street Bloods, well, you're sending a message. That's the point that Special Agent Coleman was making. Not that everyone who has a 5-point star, everyone who has a red, whatever, 5 on their arm, or a tattoo that could be considered, a gang identifier is a gang identifier. It's what it's used in conjunction with. It's the behaviors, it's the language, it's the message that you send along with your tattoo, which is exactly what this defendant did throughout his Instagram. He talked to you about some of the graffiti that he saw in relation to the area at Wendy's where Mr. Brooks was killed. He talked about the identifiers as it relates to Mr. Brooks being a member of the Pirate Bloods, and that being the purpose and why the members of Pirate Bloods gathered in this area, and the things that he saw. Then he talked to you about what we just referenced, some of the common signs and symbols of members of the Pirate Bloods, all found in the defendant's Instagram states Exhibit 153. About those hand signs, what they mean, the message, and the significance that they are to the members of the Pirate Bloods and this defendant, Julian Conley. He talked to you about each one of these hand signs and why it was important to his analysis. That this defendant was a gang member. This defendant used his gang membership to commit criminal acts. Why the tattoos on his body were significant as it relates to his ultimate opinion and conclusions. We talked about the background of not only the Bloods, but specifically the Pirate Blood set, and how and why it's a criminal street gang. He talked to you about this defendant, as he referenced his autobiography, and as you can see, admitting he was a Pirate Blood. Before he was a Pirate Blood, he was in G-Shine, set his bloods. And it's not something somebody sent to him. He told him his autobiography because he's the author, ladies and gentlemen. He is sending that and letting whoever he's sending it to know his affiliation and his background. The judge, as we talked about, is going to talk to you about the use of firearms, the possession of firearms, and how that relates to criminal gang activity. We saw firearms all throughout this defendant's Instagram, having, needing, and his want for the fact.
Keep a gun, I keep a Glock G-lock in my back pocket. Pocket rocket, let it pop it, let it go berserk. Blood stains on my shooting, on my t-shirt. Said the nigga moving pounds, but it's cheap work. Yeah.
That video, and I played it a couple times with especially Coleman. I wanted to play it again for you, ladies and gentlemen, today, because that video describes exactly what this defendant did on July 4th of 2020. He used his gun, and as he described, he let it go berserk, so he could get stains of blood on his shirt. And on July 4th of 2020, the stains, the blood on his shirt was of an 8-year-old child. An 8-year-old child. 8-year-old Secoriea Turner. Again, there's more photographs, firearms. After the incident, this defendant is seen again a few hours later. Same shirt, same satchel, same firearm. Special Agent Coleman talk to you about the circumstances surrounding why this defendant was there, why members of his gang were there, why that territory was important to the Pirate Bloods, and they engaged in this pattern of criminal conduct, that they were blocking the roadways, that if you didn't submit, that you were threats of violence and actual violence was imposed upon you for not submitting to their authority. And then lastly, as it relates to subsection E, the judge is going to talk to you about, again, the existence of a criminal street gang being required, and that the defendant encouraged another to participate in criminal gang activity, and that the defendant was at the time an associate or member of the criminal street gang, here the Pirate Bloods. What do we know about July 4th of 2020? We know this defendant was asserting authority with the members of his gang. He was doing so he could control the area of Pryor and University, that people would submit the power and the authority that he exhibited and exuded, and if he didn't, it was, in his eyes, disrespect. And anyone who disrespected him, we either met with violence, threats, and in this instance, death. Little Secoriea Turner died because her vehicle just attempted to go home. Little Secoriea Turner died just because she wanted to go play with her cousins. And if that wasn't convenient for this defendant. Now, in a moment, I'm going to sit down and the defendants will have an opportunity to address each and every one of you. And then Ms. Young will have an opportunity to go through all the facts and circumstances from July 4th of 2020 and everything that you heard as relates to the testimony and the evidence during this trial. Thank you.
For the defense argument? Need a break? You need a break? You ready? Okay. Okay, counsel, you just let me know a few minutes ago that your screen is not working. Do you need that? It's back up? Okay. But you can feel free to turn that however you want to, and we can also call for tech help if you need it. Do you want to get started?
Yes.
Okay, go ahead.
Yes.
That's fine, yes.
We've gone from gang to armed militia, and I guess if we go much longer, we'll be a terrorist organization. But, as I said, what a week ago, when you rush to justice by rushing to Julian, you disregard the fact that the math, the mom, and the man behind the wheel all agree. Julian did not do it. When you rush to justice by rushing to Julian, and Detective Shepard is your shepherd, you end up lost in lies, half-truths, conflation, and exaggeration. Detective Shepard could not utter a sentence without a noun, a verb, and Julian Conley did it. A noun, a verb, red distinctive shirt did it. A noun, a verb, red distinctive shirt, white distinctive writing, dangling AR-15 in a satchel. Detective Jerrion Shepard, Jarionshepard, sat there, blue suit, gray shirt, blue and yellow tie, dangling lies, half-truths, conflation, and exaggeration dangling from his tongue. Okay, my name is Arnold Regas, and I am proud that I am joined by Mr. Sean Hoover and Miss Aisha Broderick. And it is the pride of our lives and careers to stand next to this young man, Julian Conley, and his family, while they stand next to Shepard, a man who wouldn't know the truth if it smacked him in the face, unless it took less than 8 days to find it, because the investigation took 9 days, except when he sat in that seat, he may have said, oh, I may have done that in 8 days. Julian deserves better than 8 days. You deserve better than 8 days. Secoriea and her family deserve better than 8 days. You talk about that beautiful young girl wanting to go to Spelman, loving to dance, loving to love, loving life. And you take 8 days to investigate. He sat there, blue suit, gray shirt, blue and yellow tie, dangling lies, dishonesty, deception, half-truths, conflation, and exaggeration. And I apologize, I'm emotional, I'm loud, I can't help that. I know the state said it's not about emotion, it's not about passion. But I'm gonna be me, I can't help that. I am a poor kid from the projects of New Orleans, the Calio Project, and this is just who I am. But when you rush to justice by rushing to Julian, and Shepard is your shepherd, you're left with lies, half-truths, exaggeration, and conflation. And he knows it. He knows it. Ladies and gentlemen of the jury, I like red too. My fraternity loves red. Sometimes I walk around with my red backpack and I'll hear judges talk about you and that red backpack. I see you walking all down the street with that red backpack. It's the first thing I notice. Before I notice your 6'4" person behind in chambers, I notice that red backpack. Because it kind of stands out. Well, ladies and gentlemen of the jury, and I don't do this to be hokey or corny or inflammatory, but this case is brought to you today, or my closing is brought to you today, by the color red. A few years ago, 2 years ago, my wife and I went to a football game. We went to see the University of Georgia play. Had really good seats. But the problem is, they were on the visitor side. And I bought this red jacket to stand out to show my support for Georgia. And I thought it would make me distinctive when I watched the game in the opposing side. But it didn't. Because it was a Peach Bowl a couple of years ago, and they were playing Ohio State, and they wore red too. I didn't stand out at all. I bought this bright red jacket for nothing. Because I sat there, and there was nothing distinctive. It was just me and a sea of red. But the case talks a great deal about the distinctive red shirt, and I will try to get it right from the lips of Shepard. Red shirt, distinctive white lettering, light colored jeans, satchel, dangling AR as he sat there in a blue suit and gray shirt and yellow tie, dangling lies, half-truths, conflation, and exaggeration. I don't know where to begin with him. do it in less than 8 days. Because I don't want to take too much of his time, because on the 9th day, I guess he has something else to do. 8 days! Secoriea deserves so much more. As I said, I'm a poor kid from the Calliope. And I don't have a brother or a sister. I'm an only child. But I have daughters. I'm a girl dad. I have 2 daughters. I am a girl granddad. I have a girl granddaughter, Ava. Secoriea should have gone to Spelman. My daughter, my younger daughter, went to an HBCU. She didn't go to Spelman, she went to Howard. HU, you know. And to say that it took me 9 or 8 days, because within that 8 days, he had clues upon which he never acted upon. Within that 9 days, he was told things that he did not bother to pursue. But first, we're going to talk about a few of his lies as he sat there with that smug face. He talked about the fact that Omar Ivory showed him some pictures of the people he saw shoot. But when that man, Detective 1, with a blue suit and gray shirt and blue-yellow tie, with lies, dishonesty, conflation, and correlation dangling from his lips, when he sat in his seat, after he raised his right hand and swore to tell the truth, the whole truth, and nothing but the truth, he sat in his very seat and said to you, yeah, Omar came to me. There was some information he got offline, and all he did was pass it along to me, but he couldn't confirm any of it. It is hard to tell 2 lies in 1 sentence. He managed. Lie 1. Omar was merely passing along information. No, what Omar was doing was saying, here are the 2 people who shot. They're circled. One is tall and dark with a beard. The other is short and light-skinned with dreads or twists. That is what he said. And then that man who sat there with the blue suit and gray shirt and blue and yellow ties with lies dangling from his lips then went on to say, but he couldn't confirm any of it. Lie number 2, because when Omar sat there, Omar said, I definitely told him, those are the 2 people I saw. When Detective Shepard said, did you see him with your own eyes? Omar said, hell yeah, I saw him. I wouldn't lie about nothing like that, dog. Hell yeah, I saw him. Those 2 people I have circled. Those are the 2 people who shot Secoriea. Dressed in black, dressed like bounty hunters. That is what Omar said, but what he said was, just passed along a note. Couldn't confirm anything. 1 sentence, 2 lies. I bought this to go to a fraternity function like 30 years ago. Once again, it wasn't distinctive because everybody was dressed like me. And Then Detective Shepard said about the McCords, he identified that person went to his car. He said that person had on red when he went to his car with the shotgun. That was not true. The McCords, Mr. McCord, said that a person came to his window with a shotgun wearing black. And another person was standing in front of the car wearing black. Now, I want to be clear. I know nothing about guns. Despite what I do, I know nothing about guns. But people keep telling me there's a big difference between shotguns and rifles. Fine. But no one ever said anything about Julian with a shotgun. It was always red shirt, white distinctive writing, light jeans, satchel, dangling, not a rifle. But he sat there and said the McCords identified him in his red, untrue. But when you rush to justice by rushing to Julian, sometimes the truth doesn't matter. And when shepherd is your shepherd, it certainly will not. So let's talk about what they said. They said they saw the barricade. They went around the barricade. I think Omar said he may have slowed down for a second, but then he accelerated around the barricade. And that's when they saw people there. The people were saying, whoa, 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 as if to try to get them to stop. But then Omar proceeded through that barricade, sped up, went a little faster, and went through that barricade. And when he went through that barricade, people started shooting. They got down to that second barricade, and eventually they got to a place and they stopped. And they turned around, and about 3 or 4 minutes later, they came back through the area. They came back through that area where those bullets had met them once before. And then he said he drove to the hospital with 2 flat tires along that right. Whether they were shot out or what, we will never know. But 2 flat tires. He got to the hospital. And that's when he got out again. He started talking about, I'm gonna get me a lawyer. He said that when he told you, I'm gonna get me an attorney. His attorney went inside. And then you heard from the officer, first one on the scene, the first one that the first description he got was of people in black. People in black, or a person in black. And then a day or so later, Detective Shepard, went and talked to the families. He said he wanted to give them time, so he went and talked to them. And what he said when he testified was that, so Ms. Turner mentioned a couple of different people. She mentioned a person in black, but she mentioned a light-skinned person with twists. I think I won't call that a lie, but as the saying goes, there are lies, there are damn lies, and there are half-truths. Well, that was a half-truth. That was a half-truth. Because what Ms. Turner said was that there was a light-skinned person with twists, wearing all black. Keep in mind that that is the identical thing that Omar told him of the person that was circled. Light-skinned person, short with dreads. Nothing different. But when he testified, he failed to mention the part about her saying that that person, the light-skinned person with dreads, that Omar described and showed to him was wearing all black. Because you rush to justice by rushing to Julian, and shepherd is your shepherd, truth don't really matter. She said all black. And then, another point, she said black pants and a white t-shirt. Never did she ever say the word red. And speaking of red, I feel a little ridiculous now. She never mentioned the word red. Then, of course, as we talked about, when Detective Shepard, their shepherd, met with Omar later that day with that picture, he never mentioned the word red. I like red. I think red stands out. Red is the kind of color you notice. You notice red. There's a person sitting on the second row now. I don't even have to look, but I know that she has on red. I know that when the McCords got out of that car, Mrs. McCord had on red. They talked a great deal in their opening about distinctive red. How distinctive is it, yet no one noticed it? And that's because the math, the mom, and the man behind the wheel all agreed. Julian didn't do it. Because had he done something, they would have said the dude in the red shot, that guy in the red shot. The guy in the red put a gun to my face. But what you have here are quite a few failures. As the state just talked about, gang, inflammatory word, gang, and more inflammatory words, armed militia. There's an elephant in the room. And I don't mean Delta. There's an elephant in the room. The city of Atlanta abandoned them. The city of Atlanta said, y'all good over there. So when you talk about this armed militia, when you talk about this gang, when you talk about this, may I call them a terrorist organization, and beat them to the punch. Talk about the failure of your government. Abandon them. You heard that detective say that, yeah, they call that an autonomous zone. It makes sense to me. We didn't even go over there. We left them alone. Shepard even, I'm sorry, let me give him his proper respect. Blue suit, gray shirt, blue and yellow tie with lies and dishonesty and half-truths dangling from his tongue. Even he said it was an autonomous zone. They abandoned him and came up with a really catchy word, a catchy phrase for it. No, that's abandonment. You don't get to rebrand your dereliction of duty and blame someone else for it. They weren't there with guns by choice. They were there because in their minds they had no choice, because the city of Atlanta abandoned them. The city failed them. And you talk about it being a gang and a militia. Did you hear Miss Alloway yesterday? Did you hear the anguish in her voice? Did you hear her tell you that we were there because of injustice? We had George Floyd, Ahmaud Arbery, Rayshard Brooks, and that's why they were there. She went to that Wendy's the day after it burned down, after Rayshard Brooks. Let me ask a rhetorical question. Why do people say Black Lives Matter? Why did Black Lives Matter become a rallying point? A dumb example. My wife and I were in China once, and one of us said, "Why do I see no Chinese food restaurants here?" Well, because it's just called food in China. Because it's there, you know it's there. Why do people say Black Lives Matter? Why does it become a rallying cry? Because they feel Black lives don't. They have to say it over and over again, convince themselves, and maybe they'll convince others. We matter. That's why she said they were there. It had nothing to do with gang activity. It had nothing to do with being an armed militia. It had everything to do with saying, we matter. See us, feel us, understand us, if you will. And that's why they were there. She told you that every day. It was a group of 10 or 20 of us every day, but then every other day, hundreds or so people may come by and take pictures and tag themselves. It had zero to do with gangs and everything to do with community. Did you hear the video they played of the bus? And man went to that bus and said, wait a minute, they're for the community. Let them through. They're for the community. Because that's what it was about. It was about community. It was about, damn it, our lives matter. See us, feel us. And perhaps, if you will, try to understand us. That's why they were there. And to call that an armed militia. To diminish that to gang taking over that barricade. No, Miss Alloway told you she was there too with her AR because our government abandoned him. Our government failed him. Our government said, nah, dog, y'all good over there. In fact, even after the shooting of that beautiful little girl, even after, they didn't come. They went to a staging area a half mile away. The man with the lies dangling from his tongue told you that it was about 12:30 or 1 o'clock before he got there. Well, it happened at 9:45. But the city abandoned them. 9:45, and they got there 1 o'clock or so. They went to a staging area. But even worse, at some time prior to 9:40, is when the McCords say they went there, and we know the McCords went there, we know the McCords call the police. They call the police, and the police, they work a half-mile away. Query me this. Had y'all gone there when she called? Had they gone there when the McCords called? Had your police responded when the McCords called? No, it's a failure on so many levels. You know, we watched that video, and I believe we played all of it. It's 10 minutes from 9:40 to 9:50 on University Avenue from camera 2, and we're going to show it again. When I asked that first officer, when I said the mood was festive, wasn't it? Or they may have asked it, and he's like, with disdain. Nah, I didn't find anything festive about it. There were kids doing cartwheel. I ain't seen anybody doing cartwheels. There are people cooking out. Well, you can call it that if you want. The disdain in his voice for the people left abandoned. I have to give Detective Shepard credit for one thing. For a bit of humor. When Ms. Broderick asked, weren't there kids there? His response was, I ain't seen the kids. I call that a small adult. Huh? Well, when you watch the video, you'll see that small adult doing cartwheels and backflips, because small adults love cartwheels and backflips, clearly. But he couldn't even admit that. He couldn't even admit that. But they talk about this was gang activity. I don't have a lot to offer you. I don't have a lot to offer you. The one thing that means everything to me when I stand before you humbly, to the extent I can be humble. But when I stand before you humbly, the one thing I offer you, the one thing, and that's credibility. Because that's the kind of thing that when you lose it, I don't think you get it back. And I don't know that you deserve to get it back. And I want to maintain my credibility. I don't want to say anything to you that's not true. And I hope I don't by mistake somehow. But credibility is everything to me. And when that man looked at that video and saw cartwheels and said, I didn't see adults, I didn't see children, I saw small adults. Come on. As he sat there with that smug look on his face. But now is the time I would love to be able to walk over here and look at Julian and look at his family. I would love to be able to say, Julian was not in the gang. He was just a capper. He was just a pretty noob. That's all he was. He was just a capper. But I can't. Not credibly. I am not going to do there were no children, there were small adults thing for you. You deserve better. He deserves better. Deserve better. Julian was in the gang. Julian was a dumb 19-year-old kid from the suburbs with law enforcement parents and decided that he wanted to be a pirate. Julian was a dumb 19-year-old who decided he wanted to be a rapper dog. I don't know if kids say dog anymore. He wants to put on the grill and grab the mic and rap about niggas and bitches and all that stuff because he was a dumb 19-year-old. A dumb 19-year-old say they say was the leader of the pack. They say when he went to that bus with that older dark-skinned black guy who was saying, y'all in the community, y'all going through. They say, oh, that's Julian leading that. Julian is leading that. You see, that's just... I am not going to lose my credibility for the sake of any case. But when you rush to justice by rushing to Julian, and you can't bother waiting for 10 days, 10 days is too many, the things like truth and credibility are out the window. But they call that a gang. Because when this happened, July 4th of 2020, 5 years ago, and whoever put up these charges, and they went our district attorney's office, a year or so later, they said, it looks good, it looks good, it looks really good, but you need to add something. Can you take this and see if you can find a gang angle to it? And then it was turned over to Homeland Security and whoever to look for a gang angle. To look for a gang angle, to search for a gang angle. Let's check his Instagram. Let's see what Instagram says. And Instagram said a lot. Instagram said he was a dumb 19-year-old looking to be cool, joining the gang and trying to be a rapper, dog. But as the saying goes, when your only tool is a hammer, every problem is I know y'all said it to yourselves, nail. When your only tool is a hammer, every problem becomes a nail. They decided that the police should look for a gang angle a year or so later. And Coleman, Special Agent, Homeland Security, whatever, his title is not as nice as Detective Shepard's. He said that I looked at that video and I saw he had a leadership position again because that dumb 19-year-old went to a bus with an older guy. As the older guy said, no, come on through. You're for the community. But that somehow became him. Let's watch that video. We're going to try it again, maybe. I don't know if you could hear the part about, you hear from the community. Let's play it again. Let's play it again for the cheap seats in the back.
If there's any microphones on over there, that's causing the echo.
So, in that video, you have the 19-year-old and the older guy walking to the bus. The 19-year-old was somewhat a few steps, a few paces behind the older guy, and the older guy is saying, "You're for the community. Let's let him through." And you have the younger 19-year-old guy standing back there. Didn't exercise any veto power or say, "Hell yeah, let's let him through." That's what I said first. No. Just a young 19-year-old following the crowd in that case, except in this case, he was following it for what he believed to be a noble purpose. Let's talk a little bit about the testimony. Words like Black Lives Matter, or at least they should. I don't know if you remember, again, way back when I stood before you and I did what's called an opening statement. And I never know quite what the evidence will show. I try to guess what the evidence will show, and I cross my fingers and I hope to get it right. But when I stood before you a year ago when I did it, I was terrified. My voice was cracking. I think I misspoke a few times. And what I said was something about when you rush to justice by rushing to Julian, it invariably, something I said. And I said that, but when the mom, and the man behind the wheel all agree, or at least they did. I said that because I didn't know what they would say when they testified. And I didn't want to say that they agreed that he didn't do it, but I knew I could say they agreed because of what they said then. But when they testified, I was expecting them, one of them, any of them, all of them. They could have stood up and said it in unison. I was expecting for them to say, "Do you see the man, one of the men who fired those shots that night in this courtroom today? Do you see him?" And I was expecting them to stand up because I didn't know, yeah, that's him. But they didn't ask that question. They did not ask that question. And there can only be two reasons why they didn't ask it. Either because they didn't know what the answer would be, or because they knew exactly what the answer would be. And then, when Omar sat there, I was waiting for them to ask him. Omar's a wild card. Do you see that person or those persons in that picture you photographed, or the people who shot at you? Do you see that person in this courtroom? I was expecting him to say, yeah, dog, I see him. I see him right there. But no, they didn't ask. And they didn't ask, and there can only be two reasons. Either one, they didn't know what he would say, or number two, they knew exactly what he would say. But they didn't ask. They did not ask. Yet, when young lady Jasmine from Cobb County, who loved sitting there, I think she gave you all the peace sign when she walked out, loved sitting there. When she testified about the gender reveal color thing that somebody threw under the car, they had no hesitation. They asked her, do you see that person in this court right now? She stood up and said, yeah, that's it right there. And when Shepard sat there, we knew what he was going to say. They asked him, do you see the person? Oh, yeah, that's him right there. Red shirt, distinctive lettering, light colored jeans, satchel, AR dangling. He is the only person I've ever seen to look at a black and white video and say, that's him in a bright red shirt. They never asked that question. I hope what I say doesn't come across as being cynical. I have a great deal of respect for Ms. Turner. As much as they wanted her to say she saw somebody in a red shirt, she never would say it. All she would say is black shirt, or at one point, white shirt, black jeans. She never would say red shirt. Never. Omar. And I can't help but sometimes come across as being a little bit mocking. A little bit. I can't help but have a bit of respect for him either, because he never once, as much as they wanted him to, he never once said red shirt. He never once said red shirt. Even when you look at the McCords, he never once said red shirt. They didn't even ask him, do you see the person or people? Never didn't ask him. They didn't even ask his wife, do you see the person? No, never asked. So you have to listen to what they ask, and sometimes listen more closely to what they don't, because they only have two reasons for not asking. Either they don't know, or they do. But they didn't. So as the McCords drove off that night, made that turn into that package store, saw him pull out the car, pull over the car, and get out of the car with the gun in his right hand. Again, I don't know guns, but he said it's a .380, and my gun people say a .380 is a small gun. But you see him get out that car with that .380 in his right hand. And he said just as much from that stand. He had a gun in his hand when he got out. And I don't know if you listen to my questions or not. I forgive you if you don't. But my question to him was, in response to you pulling out that gun and getting out of that car with that gun, did you even know that those 3 or 4 or however many people pulled a gun on you in response thereto you having your gun? His response was, I didn't even know. I didn't even know. But when you look at that video, you'll see that he pulls that car over, he gets out with his gun, he says whatever he says, he turns around, then his wife in her distinct red, gets out of the car, and she says something, and then they get back in the car, and then they drive off. And then after, you see young 19-year-old come over with his gun. He didn't even shoot at the people who had a gun in his hand, yelling at him. You see him come out, get out of this, walk over there, and does a little thing like this for a second, and turns around and walks away. And the courts never do anything about that. Hey, we're gone. You know, I really enjoyed learning a little bit more about Mr. Abadi. I have to say that. You know, I don't know if you all gather this throughout this process, but I'm going to speak for myself. We don't hate each other. In fact, I think they're good people. Great lawyers, better than I can ever be, but great people. I really respect, well, most of them. I haven't gotten to know one of them. But just a good guy. But a trial is not about us. It's not about me. It's not about them. And to some extent, of course, it is about him. But it's also about us, the collective, all of us. A trial is about who we are and who we say we are. It's about what the judge is going to tell you. They have the burden of proof. He has nothing to prove. Zero to prove. He doesn't have to say anything, do anything, show anything. All he has to do is sit there. Nothing to prove, and they have everything to prove. That is about who we are. So it's not about, well, he didn't do this, he didn't do that, I wish he'd have done this, but damn it, he ain't got it. Because that's who we are, and that's what we say we value. So it's about him, yes. Not about him, not about me, about us, about what we say, the values that we say we hold dear. It's about the judge is going to tell you that if you have a grave suspicion that he did it, and only a grave suspicion that he did it, your duty is to find him not guilty, because a grave suspicion is insufficient. The judge is going to tell you that you can only convict if there is no reasonable alternative theory consistent with innocence. The judge is going to talk to you about reasonable doubt. And as Mr. Abadi said, you know, lawyers, we screw things up. I don't know if he said that, but I think he meant that. We screw things up with words. We take words that should be simple and we butcher them. We mess them up somehow. A couple weeks ago, I was in a trial in Clifton, Georgia. And the judge did something I've never seen a judge do. At the start of the trial, Judge Reinhardt, he said, call him Bill. He read the Pledge of Allegiance. And I'm thinking, what? In the courtroom? You know, a little separation of this? Details. And I'm going to be, again, as Mr. Body was frank with you about, I'm going to be a little bit frank with me. Rightly or wrongly, I've never considered myself a patriot. I thought you sort of had to somehow earn it. I'm not like Ms. Broderick, a veteran of war. I didn't think I earned the right. But it took me to the last time I even heard the Pledge of Allegiance, and it was at my dad's funeral. when he was given the flag from his military service of having gotten on a boat and a plane and gone to Vietnam. And the minister, who was an officer of the military, talked about justice and what it means and what he fought for. And I was like, wow, I believe in justice. I believe in fighting for it. I'm a patriot. And I am. He talked about you don't have to love everybody or like everybody, but that doesn't matter. You don't have to like what everybody says, but that doesn't matter. We're all, as Mr. Body said, we're cloaked. We're cloaked in this thing that has to be more than a thing, an idea that has to be more than an idea. It has to be who we are. And this idea, it's not about your suspicion. It's not about I believe he did it, I believe he didn't do it. It's about did they prove it beyond reasonable doubt. And that's who we are. At least that's who we say we are. And as, you know, lawyers mess things up, the way I think of reasonable doubt, my wife and I were watching TV a few nights ago. I let her have the remote control this time, or as I like to call it, every time. And she does what she always does. She found her way to a documentary. And this documentary was on CNN. And it was something called, How Did It Happen? Why Did It Happen? Something like that. And it told the story of this young girl. I think her name was Mary Kellerman, a 7-year-old girl in a suburb of Illinois, suburb of Chicago, rather. 6 o'clock one morning, wasn't feeling well, it was time for school. And her dad did what a dad would do. I've been there. My wife's a flight attendant. I was always at home with my 2 daughters, trying to comb hair. Haven't gotten that right with myself. But the dad gave his daughter a pill. And shortly thereafter, he heard her collapse on the floor, dead. And a few miles down the road in that suburb of Chicago, you had the Janus family. 3 people were sick in the Janus family. 3 people took a pill. They all died. 4 people dead near this little suburb of Chicago when someone figured out the Tylenol was killing them. I know Tylenol is in the news now, but we're not talking about that. Tylenol killed them. All in all, 7 people near Chicago died because someone, before the age of childproof locks and all this other stuff, someone had poisoned the Tylenol. 7 people died. And what did Tylenol do? Tylenol removed every bottle of Tylenol off every store shelf in Chicago, in Illinois, in Atlanta, in Idaho, in California. Every Tylenol in the country was pulled off the shelf. Not because the makers of Tylenol believed their product was deadly. They did not believe it was deadly. But they had a reasonable doubt. And that's what reasonable doubt is. It's not about math. It's not a 1 out of 2 chance, a 1 out of 10 chance, a 1 out of a million chance. The numbers don't matter. That ain't about math. It is about reasoning. And Tylenol deemed the threat too severe. too severe. The threat too reasonable. And they pulled it off every shelf. That is a reasonable doubt. Or another way to judge reasonable doubt, when the man with the blue suit and the gray shirt and the blue yellow tie with lies and half-truths and conflation and exaggeration says anything, that too is reasonable doubt. Let's watch videos. I want you to get a feel as best you can of what the night was like. Is anything happening anywhere? Oh, okay. small adult doing cartwheels? Small adults love that. Backflip too. going to finish like I started. I guess had I gone to a Wake Forest game and watched Mr. Body's brother in their black and gold, perhaps I would have stood out in my red, but I didn't at the game I went to. Or perhaps had I been on that University Avenue that night, I would have stood out. Or perhaps if Julian had been in that red and white actually doing something, he would have stood out, but he didn't. I hope you got a good look at the video at both of them. I hope you saw community. I hope you saw kids, small adults doing cartwheels. I hope you saw that guy walking his dog. I hope you saw the grills and the smoke. I hope you saw families. They were there for community. They were there to uplift their community. They were there to love their community. And because they're abandoned by the city whose job it is to serve and protect, the city left them unserved and unprotected. They were there to serve and protect their community. You heard Ms. Salloway. Every day they were providing food for people. They got in the bathroom. They were going to get 2 showers that day. Ms. Salloway planted a garden. They were there for community. There was no meeting of the minds to take over. This is blood territory here. The only gang Ms. Salloway was in was a gang that loved her community. That's all they were there for. There was no meeting of the minds. There was no, let's block this street. Let's show our dominance. Let's show our conscious and deliberate and intentional. Let's show dominance. They never showed even who put the barricade there, because they abandoned that area. Yet they come in here throwing words around like gang and armed militia. And all they have is shepherd. Shepherd is their shepherd. He told Agent Coleman what he wanted to tell Agent Coleman. He showed Agent Coleman what he wanted to show Agent Coleman. He put circles around that video so that you will look where he wants you to look. We don't even see the whole McCord interaction if it happened 2 minutes before this. We don't see that. So clearly, there's a blind spot in his video. Clearly, there's a blind spot in his heart. When I think more about that second video you saw at the last barricade, and you saw that car go by, and you saw the person kneeling or squatting, and you saw him creep behind the barricade. Shepard had an answer for that. Oh, he was ducking for cover from Julian Conley's fire. Is that what it looked like to you? Really? Really? Is that what it looked like to you? Well, I have news for you. That's not even what it looked like to him. But when you rush to justice by rushing to Julian, you don't really care about truth. Now, the way the rules work, I don't like these rules. I have to sit down. I don't like that. I'm scared. I'm scared like I was last Wednesday. I'm scared now because once I sit down, no matter how much I want to, and I'm sitting right next to Julian, no matter how much I want to, and no matter how much he wants me to, and his family, they want me to, I won't be able to get up again and say another word to you. They will, and that's why you see them typing furiously away, because they're typing real time a response to everything I say. You didn't say that right, you didn't say that right. Oh, I got you on this one, I got you. Aha. The rules don't allow me to do that. The rules don't allow me to answer their questions or question their answers. The rules tell me I have to sit quietly because they get the last word. Except they don't. You do. You do. You get the last word. You get to tell them. You don't get to rush to justice by rushing to Julian. You get to tell them when a mom and a man behind the wheel all agree. So should you. You get to tell them that. You get to tell them that that girl's life is worth more than an 8-day investigation. You get to do that. You get to tell them, you see those pictures he gave you with those two people circled? How come you didn't look for those people? How come you didn't look for those people? How come you didn't do a bulletin with those people on it? You get to tell them that we live in a day and age where you can cheat on your wife at a Coldplay concert on Friday, and by Saturday morning the world knows your name and her name. You get to tell them to do more. You get to tell them that girl's life was more than 8 days. You get to tell them her life was worth more. You get to tell them with the t-shirts and the placards and all say, Black Lives Matter, her life should matter. You get to tell them that. You get to tell the city of Atlanta, you don't get to wash your hands of a community. So just as my dad got on that plane and that boat and went to Vietnam to fight for the thing that we call justice, for the thing that we say we believe in, and I know we do. I know we do. You don't have to get in that plane or that boat and go to some foreign land and step foot on some foreign soil. Sometimes you get to get a jury summons. Sometimes you get to read that jury summons and say, oh, hell. But sometimes despite saying, oh, hell, another one, you come here and you sit through 2 days of questioning and thinking of, what do I say to get out of this? Well, sometimes you end up sitting in that seat where you're sitting right now because you get to apply your common sense and your reason and your life experiences. Without going to Vietnam, just by getting in that car and coming here and getting on that shuttle and walking into this building and sitting in those seats. Some of you are already, but you're all veterans now. You all get to fight for justice. You all get to tell them that child's life matters. You all get to tell them it should have been more than 9 days. You all get to tell them you don't get to rush to justice by walking me to tell them that by finding Julian Conley not guilty of all charges. I thank you for your attention.
Before the next argument, which can last a little over an hour, do you need to take a break? About 15 minutes? 15? 10? Okay, 10 minutes, guys.
All right, for the jury.
Okay. 10.
All right, for the jury.
I'll be watching.
Mr. Regis is absolutely right. I am over there typing feverishly because at that table, we carry the responsibility and the burden of making sure that we bring you absolutely every piece of evidence to prove that this defendant is guilty beyond a reasonable doubt. And I take my responsibility serious because it's important. This matter is important. It's not a joke. It's serious because an 8-year-old little girl is dead. So I'm going to apologize in advance if I repeat myself, if I go over stuff that Mr. Abadi may have gone over, but I don't want to miss anything, because I don't get a second chance to ensure that Secoriea gets justice, the justice that she deserves, the justice that her family has been waiting on for 5 long years. Now, Mr. Reagan talked about failures. I'll tell you what the failures are. The failures are over there at that table. The failure to take responsibility for what the defendant has done. He wants to put the blame on everybody else except for where it should land, and that is on his shoulders, nobody else's. He talks about the police weren't there. But what they don't want you to know, the police weren't there because the police were the ones that were in danger. They were supposed to be out there protecting the community, loving the community. But in all actuality, they were terrorizing the community. The police were their target. So the police said, you know what, let us back off. Let us give them their space to allow them to express themselves however they want to. But then it turned dangerous. And the police had no other choice but to come. So don't make them think it's the police fault that he decided to pick up an AR-15 and shoot and kill an 8-year-old little girl. It's not the police's fault. It's Julian Conley's fault. Omar rolled back through the barricade. Now he kind of glanced over there because it would look crazy to blame a man who was driving an 8-year-old child who was bleeding to death in the backseat of a car. So he wanted to glance over that. But Omar said, I didn't know what to do. But you know what's the closest highway to get to? You got to go back through there. Otherwise, you got to go all the way around to Hank Aaron to try to get back on the highway. He was trying to get Secoriea to help as soon as he possibly could. Detective Shepard, and this is repeated, a rush to judgment, a rush to judgment. What did he tell you? I followed the evidence. I followed it, frame by frame, hour by hour, minute by minute. And you know where it led him? To Julian Conley. Now let's talk about when the defendant showed up 9 days later, because I want you to make sure that's the map. When Detective Shepard took out those warrants, that's because Julian Conley showed up and said, it's me in the red shirt, it's me in the light jeans, it's me with that AR dangling in between my legs. Because he already knew he was responsible. But did he take responsibility that day? Oh, absolutely not. So when you want to talk about 9 days and a delay and justice, it don't land with Detective Shepard. It lands with Julian Conley. Because he knew from day one. I'll give him day 2 when the news came out, because he was too busy over at Edgewood on day 1. Lies and exaggerations. There's lies and exaggerations over here, but it don't come from the state. It don't come from the witnesses that the state brought to you. It comes from the defense witnesses, and we'll talk about that. He a dumb 19-year-old, and he's in a gang. That ain't an excuse, ladies and gentlemen, to gun down a car and kill an 8-year-old girl. I have a 19-year-old son. It is unacceptable. He came from a family. Law enforcement, so you know better, so you do better. He chose to do what he did. And therefore, he should hold and take responsibility for what he did. And not just try to say, oh, I'm 19.
I'm going to remind you that the state has the entire burden of proof. They've got to prove each and every element of each charge in the indictment beyond a reasonable doubt. There is no burden whatsoever on the defendant, and that burden never shifts to the defendant. Go ahead.
Being 19 is not an excuse to kill an 8-year-old girl. They talked about half-truths, lies, dangling off of Detective Shepard's tongue. Well, what they got up here and told you, Mr. Regas, he got a difficult job. I had Mr. Regas' job at one point. And I went to a training, and what the trainer told us in the criminal defense advocacy is, If the law is on your side, argue the law. If the facts is on your side, argue the facts. If the law and the facts are on your side, argue them both. If you don't have either, just argue. And I submit to you, ladies and gentlemen, that's what Mr. Reagan did here today. He just stood up here and argued and said anything, because that's what he got to do. But he wants to tell you there's kids doing cartwheels. I want y'all to think back and remember the context in which Miss Barbara was showing those children. She was talking about who in the red shirt is shooting. Who in the red shirt got a gun when she pointed at those kids. That's what she was talking about. Don't let them give half-truths to make it seem like that we're glossing over that there were other kids out there. There absolutely were kids out there. Kids that were also in danger, and thank goodness they were not shot and killed too. They failed to mention that the kids had to duck down as those shots are ringing out. Because I hope y'all saw them run and scurry, running behind cars and hiding. That's what this defendant's actions caused the children out there to do. And they only showed you a portion of that video. I hope y'all remember because we played them over and over again, zooming in, zooming out. On that other side where that Williams tent was, gunshots firing all over the place, still in the middle of the road, even after the Jeep has passed by. At no point in time has the state argued that there was only one person out there shooting. It was multiple people out there shooting. This defendant just happened to be the one who got caught. The McCoys didn't see the gun. They don't have to see the gun. When you get that indictment back there, you will read it and it will say guns being pointed in the direction of them. It doesn't say they got to see it, they even got to know about it. But we do know they know about it because we're at the barricades, and unfortunately, that video was not done right before the time that they got up to it and went inside. But you know, and we've seen that car pull up to that barricade is down in there for about 2 minutes before they pull out and pull back into the package store. So actually, they were victims of aggravated assault twice. Inside the barricade and in front of that liquor store. Party to the prom. They just went, we gonna ignore that. We gonna act like it don't exist. We gonna fail to mention that. Because if they mention that, they gotta tell you that the defendant is guilty. Beyond a reasonable doubt. Because what did Detective Shepard tell you? He didn't have to be shooting. He says he was out there, he was at the barricade, they're all acting in concert, they're all working together. Therefore, even if he did not fire that gun once, he would still be guilty of murder, felony murder, and all the other charges that he has. But what y'all know, because y'all have common sense, which they want y'all to check at the door, but I ask you, don't check it at the door. It's the defendant, his shots, that went into that car and killed Secoriea. Now, we went back and forth, we pulled up chairs, we rolling back and forth, talking about the path and the trajectory. I ain't hear none of that today. They just failed to mention it, they just abandoned that because it don't make sense. It doesn't make sense. And camera 2, there's no zooming in of the shooting. We sat here for almost 10 minutes watching that video. At no point in time do they zoom in and say, you see where the muzzle shot's coming from? That's the man in all black, because they can't tell you that because you have common sense. You've seen this man walk around with his light jeans on and his red shirt, and you know that it's him behind that barricade, stepping out with that AR pushed forward, pointing at that car, and he just starts to blast, like his rap songs say. And then, just no remorse. Y'all heard that before this even happened, the defendant is out in Cobb County committing acts of violence, endangering people on the highway, throwing smoke bombs in the middle of the highway where a woman is driving with 3 children in the car with her. Thank goodness that she didn't wreck and get hurt or anybody else on that highway. Then you get to July 4th, still behaving as a gang member, walking around terrorizing the community day in and day out. Then after that, he head over to Edgewood, still with his AR-15. And 9 days later at that press conference, want to talk about lies. Lied. Over and over again. He's 25 now. He in the jail still, wiping his nose, throwing up the gang signs with people behind him with shanks. The age is not an excuse. So let's talk about the facts. And ladies and gentlemen, I do not at all look past the fact that there were people out there for the right reason. There were people out there wanting to use their voices to combat the injustices that they believe was going on in not only in the country, but right here in our city. And they had a right to do that. Ms. Salloway, by no means do I think that she is part of the gang that Mr. Conley belongs to. But see, what happens is that they were out there for good reasons, but these individuals, being Mr. Conley and his crew, came out there for the wrong reasons, and as a result of that, a child is dead. They want to blame it on the commissioners, they want to blame it on the police, they want to blame it on anybody. But the commissioner's not out there with no AR-15s. The police aren't out there with AR-15s. It's the defendant and his crew. And that gets overshadowed. Because I do think that Salloway, nobody's out there spending the night, overnight, taking showers, from going home, using the bathroom out there, dedicated to the cause and to the mission. And we are by no means saying that was anything wrong with it. What was wrong was the behavior that this defendant took, that does not go with this group. There are various different groups out there. You got the gangs out there, you got the protesters out there, and you just got the regular citizens that's just trying to live their life. They trying to get gas, they trying to get a couple of chips from out the store, but you got these folks not even allowing them to get to their homes. And we're going to talk about that. They want to tell you it was festive, and it may have been festive. I didn't see that videos, but I don't call it a festival when folks walking around with AR-15s and handguns and following people and making them turn around. So maybe there was some bouncy houses, I don't know, but what I did see was barricades that was blocking off the street, did not allow people to get where they needed to go. There was upliftment and love for the community. That don't look like upliftment and love for me. If you can't get where you need to go, if somebody walks to your car and you're saying, I just want to get home, and you're met with a gun to your face, telling you get back in your car and turn around. They were serving and protecting their community. They killed a member of their community. That's not serving and protecting. They were out there for healing, but it ended up in harm. And kids playing, so they want to say, ended up in a little girl, Secoriea, being killed. It was Independence Day, ladies and gentlemen. There was nothing independent about what was going on the corner of University and Pryor that day. Nothing at all. Those people were they were like, I don't know, prisoners in their own community. You can't go here, you can't come up that way, you can't go down that way. Luckily, I don't know, the bus, hey, Mr. Bus Driver, we'll let you go. But there was nothing independent, there was nothing free about those moments and those days over there. And it's not fair to the people that were out there for the right reasons. And what are they going to do? They going to tell them folks to leave? They got a whole crew out there, ganged up, ready to go, because we see them every time Mr. Conley's moving, they moving with their guns pointed and ready to shoot. But we'll talk about that. And they're exercising power and control. Now, they say Black Lives Matter. We're about police brutality. And ladies and gentlemen, the evidence is real clear. It wasn't the police that the community had to be worried about out there. It was the defendant and his gang members. And the most precious and innocent black life was lost because of them. And Mr. Abadi kind of touched on this, what was the motive? And that goes all to the gang stuff. You're going to do what I say when I say do it. I told you to turn around. I told you you can't come through here. And when you don't do what I tell you to do, then I'm going to let my gun just ring. And that's what he did. And we'll get to why I think he believed it was the McCords because of the time period. And I just told you, don't come through here. And you got the audacity and the nerve to turn around and come back through here? Oh, I'm about to show you. What did Charmaine say? She heard him say, hey, like that, stop. What did Omar say? F-ins, as they're trying to just go home. Even their own witness says, she heard them as the car is pulling up. Hey, once again, trying to stop a citizen from going to and fro about their own business in a place where they have the right to do so. But until this defendant and his crew decides we're going to block it off and we're not going to let anybody do it, because they were illegal barricades. They had no right, they had no authority. Anybody had the authority and the right was Omar. He should have been able to drive through that street without having to go up on the curb, not being in fear for what's going to happen to him and Charmaine and Secoriea in that car. So let's talk about the evidence that proves this defendant's guilt. You're going to get evidence, and you've gotten evidence through the witnesses, the physical evidence, scientific, and even the admissions and the words of the defendant himself. And we talked about Aiden Coleman, and Mr. Rakes has already said, hey, yeah, he was in a gang. He was 19 old, just excuse it. He didn't really mean it. But he's still doing it. He's still practicing and acting up with the gang. Miss Duffy, and we talked about that in Cobb County. Intimidating looks, his red bandana and mask. Remember she talked about the smoke bomb being pinkish or red. Loaded down with guns and ammo. What did Officer Brazanga tell you? I'm on duty and I have about 89 to 100 bullets. He walking around with over 1,000 rounds of ammunition. Because he ready. For whatever comes along, he going to take out whoever he wants to. And Mr. Rakes got up here and said, oh, Jasmine Duffy got up here and she got up and said because the state's telling these people to do this. Oh, that's him. That is not what happened. She looked at the booking photo and said, yes, that is the man who looked me in my eyes and then threw a smoke bomb under my car while I had my baby and my nieces in the car with me, putting our lives in danger on that highway. And hollow point bullets, the most lethal bullets there are. That's what he carrying in his book bag. And the AR-15, well, that belonged to his friend. One of his crew members, one of his gang members that just took responsibility because he was already getting ready to be arrested, so we can't let them take that AR-15. I would submit you that AR-15 that they got in March is that same AR-15 that he had out there in July. Mr. Rakes wants to tell you that, oh, he's not the leader because they weren't posting. What did Ms. Salloway tell you? We didn't have to post. There were no chats going on. We knew to be out there. We showed up, and day after day, we would just come. So he ain't got to post. He ain't sending out invitations like he invited folks to a wedding. They all just showing up to run the streets. But he did post, go burn down Cobb County to get my property back. I need my guns and my ammo. He wearing his gang outfit all and through there, and we'll talk about that. He gets to decide who goes and comes in the barricades. I hope y'all, and I know y'all probably tired of looking at the video, but if y'all want to look at it, y'all get to look at it again. But there are times when you see that defendant with his red shirt on, with his white letters, moving cones, moving barricades, swinging, hey, waving people through. He is in charge. Forcing people to turn around at gunpoint because he decides you can't come through here. He told them, of course, turn around. And some people, they got into the barricade. They saw what was going on. We just going to turn around. We don't even want that smoke. And just minutes before, probably not even minutes, I hope y'all saw that white car before the Jeep comes. He walks out of the shadows. You see that white lettering on his back. He goes up to that car, and that car just turns right around. Because sometimes you don't even have to point your gun. Because I'm telling you, if it's AR dangling between your legs, I'm moving. Don't worry about it. I'm going to turn around. And he's giving directions. I know it's hard to hear, but that older black man looks at him, the leader. It's good, and he said, oh yeah, he good. He can get on. He is in charge every step of the way. He gives directions to the MARTA bus driver. At the end, when they finally let him through, he walks all the way down to the end of the barricade, and he's waving. Come on, you can come through. Not no other person. Not no man dressed in all black. Not no man dressed in, not even Mr. McKinney with his white shirt and black. It is that defendant giving directions to everybody. And I hope y'all know, he was standing post. Standing at post. All day long. That was his post, the barricades. Because they had certain points. If you saw, Mr. McKinney was over at the BP station, and Mr. Conley stayed at the barricades. And we know he had the barricades because he tells you in his press conference he was at the barricades. And when the Jeep pulls up, he approaching. He leading the pack because he in front. He is in front with that AR pointed, and he begins to fire, and the rest of them follow suit. Because I hope y'all know, is there a man in all black shooting? Yeah, but when does he shoot? After his leader. And not only does he step up, he follows the car all the way. And the physical evidence will show how he followed that car as it passed by trying to get out of danger. Leading, standing post. telling his crew where you need to go. I don't know if the McCoys went where I told him to go. McKinney, go back and check. I hope y'all looked at that video and watched Mr. McKinney run back around to the other side of that package store to do what his leader has told him to do and make sure the McCoys are gone. And then he comes back and goes and checks in once again with his leader. He's not just a gang member. He is the leader. And we know he had guns just all day long. And how y'all know it's him? He got on the same light jeans as he did on July 4th. Credibility. Now, the judge will instruct you that it is your responsibility to judge the credibility of witnesses, and yours alone. So you get to decide who came in here and who told the truth. I submit to you that the state did not put up anybody that told you anything but the truth. Now, they want to call Detective Shepard a liar, and he's not a liar. They just mad that the evidence that he got led to their client. What did Samantha and Christopher McCord tell you? They pulled up to the barricades. Mr. McCord describes a light-skinned male with a long gun. Now, I mean, it was a long gun. That gun looked really long to me. He didn't have to say it's a rifle or not, it's a long gun. He forces them to turn around, and then he gives them instructions. And then Mr. McCord, after seeing this defendant admit that he was down there, he says, that's the dude that met me when I was inside the barricades and told me to turn around. And how we know it's him that met him at the barricades? Because he follows him after he turns around. There's no doubt who that is. And I know y'all was probably tired of hearing about States 112, light jeans, red shirt, but we got to prove it. I have a responsibility and a duty to prove to you beyond a reasonable doubt that it is that defendant that committed each of these acts. And so if I got to tell it to you over and over again, I will do it over and over again because this is my one shot. Aggravated assault, like I told you, twice. Now, Mr. Ray is talking about somebody squatting down ready to shoot. It was his client. Ready to shoot. Now, Charmaine Turner, she told Detective Shepard everything she could. Not one time did she lie to Detective Shepard. Were there men out there with black shirts on, dressed all in black, dressed like the police, dressed like the militia? Yes, they were. Were they all armed? Yes, they were. Were there men in all black shooting guns? Yes, they were. He says we didn't ask her a question about whether or not it was the defendant that shot Secoriea. We didn't ask her because she said, I don't know who shot my child. I just know my child was shot as I passed through a barricade with armed men. And who would expect her to know anything else? Because he started with the mother. The mother in the back of that car. First of all, she said, I'm on my phone. Secorea's back there on her phone. Next thing I know, fire is coming into the car. I reach back to get my child, and the last words I hear my child say is, Mom! Crying out in agony and pain. So he wants her to be able to tell you about a red shirt. The only thing red that she was concentrating on was the blood that was pouring from her baby body as she tried to press on that wound to keep her baby alive. I'm a mother, and I know what that feeling feels like, to hold your child the first time they take their first breath, as their heart beat for the first time. I can't imagine the anguish it feels to hold your child as they take their last breath.
Objection, Your Honor. May we approach?
She's focused on her baby that is dying in her arms. So it is not fair for him to say, because she cannot point out this defendant, because we ain't got to worry about her pointing out. The video's pointed out. And didn't I tell y'all 2 things could be true at the same time? Could there be men in all black shooting and this defendant shooting? Absolutely, and you know it because it's on video. Omar, it's men in all black. They bounty hunters. He gave a picture to Detective Shepard. Yes, he did, because Omar is like, y'all, that man is driving that car. He made the decision to drive through that barricade. The responsibility on him weighs heavy. Y'all can see it on his face. So he is doing whatever he can, giving Detective Shepard whatever information he receives about who could have been the people out there that were shooting into that vehicle. He never said definitively that man didn't shoot. He never said that. What he said was it was men out there dressed in all black that were shooting. And is that true? Yes. Was the defendant out there shooting? Yes. So 2 things can be true at the same time. Don't try to put the onus on the man behind the wheel. The man behind the wheel was trying to make a decision in the most traumatic event he has probably ever experienced in his life. What do I do? Where do I go? Because when you pull up to that barricade and you see them people, you got to make a decision. And we came Monday night quarterback, I guess it's Tuesday night quarterback now since it come on Monday, to decide if you pull up to a barricade and you're trying to drive through, it's armed men in front of you. You don't know what they may do if you just turn around. So I'm just going to push through. And there's nothing wrong with that. He was trying to be a protector. How can I get them to safety as quickly as possible? We can't blame him. The blame lies on the person that pointed that AR-15 at that car and let off 8 rounds into it. We lucky it wasn't Charmaine, Omar, and Secoriea. And what did Omar tell you? I wish it was me. That's who's taking responsibility. And he said, I'm going to get an attorney. There's nothing wrong with that. He's like, I'm driving the car. I want to make sure that nobody thinks that I did this. I'm responsible for it. Because I don't know if you heard the little tricklings of, oh, the person in the car was shooting too. So he's trying to make sure I'm protected. But what he does say is black men and all black were out there shooting, and we know that to be true. And we also know it to be true that the defendant was out there shooting. Now, the defense witness, Ms. Salloway, like I said, I think she came with good intention, or at least she was out there for good intentions. And she was trying to do what she could to help. But the things that she told us was real important, and it was consistent with Omar and what Charmaine told you. As the Jeep pulled up, I heard somebody yell out, "Hey." The Jeep went up on the curb, and shots rang out. And she told you, as the Jeep passed by, I saw shots in the back area behind the Jeep. And the windows of the Jeep were rolled up. Now, when she get a little fuzzy on her credibility is that the man at the back barricade was shooting. Well, ladies and gentlemen, y'all get to view the videos. Y'all get to decide. There doesn't appear to be muzzle flashes. She said she didn't see muzzle flashes, but she thought the man was shooting, but she really couldn't tell us where she was standing in the Wendy's parking lot. And then at some point she started saying, well, I heard what happened. So I don't know if she heard it that night, heard it since this trial has been going on, and feels like that's what I saw. But to me, that's just a little red herring. But what she does tell you is the shot, as the Jeep returned, she heard some more shots. She don't know where they came from. They don't know who they came from. And I think she said, Mr. Ravis wants to tell you that the man was not ducking for cover. That's what his witness said. He ducking down. He moved all the way to the other side of the barricade to avoid the shots that this defendant is firing out in his directions by the barricade. She tells you men in black are shooting. Absolutely, they are. But what she didn't tell you, she never said, that defendant didn't shoot. And what, in fact, she told you he did, but we'll talk about that. And now it's Detective Shepard's fault. Detective Shepard told you I was working 12, 14-hour days to figure out what happened to this baby. I'm canvassing the area. I'm trying to get people to talk to me. I'm not getting any cooperation. The people that are talking to me, it's exaggerated for what they're telling me, because when I look at the video footage, it's not corroborated by what they're telling me. I'm getting information from social media. He never denied that there were men out there shooting in black. In fact, what did he tell you? If I could have identified them, I would have put a bolo out for them. But I didn't have any identifying photographs where I could see their pictures, their faces clearly, to put out on a bolo. He never got a positive identification for them. The only 2 people he was able to get a positive identification for was the defendant and Mr. McKinney. And when he got those, he put it in a bolo, put it out there, and he got those individuals to then come in and say, yes, that is me that you see. And we know that he's not in a rush to judgment. Because what did he tell you? I didn't charge McKinney. Because as I'm looking at those videos, McKinney is not at the barricades. So I'm not just out there trying to charge anybody that I see with this homicide. I want to make sure that I charge the right person. Because I have all the evidence to show me that it is that person. So it's not a rush, ladies and gentlemen. He's following his evidence. And thank goodness for Mr. Camber, because we were able to get that video from Martin. We were able to get those clear images. And if you recall, there are other images as that bus is turned around on the side where there are other men out there with guns, and they got them posted, they got them pointed up, but you can't see their faces. So you can't put out a bolo for somebody whose face you can't see. And he told you those are muzzle flashes. At least 2 we see as that Jeep passes by. And what did he tell you? I didn't know. I did not know who my suspect number 1 was. I knew what he looked like, I knew how he walked, I knew what he was wearing, I just didn't know his name. I didn't know his name until he showed up with his attorney and said, that's me at the barricades. And then Mr. McCord then calls and says, hey, yes, I recognize that man as being the person that pointed a gun at me. And lo and behold, what do we have? Video footage of that defendant pointing a weapon at Mr. McCord and his wife as they drove away. So it ain't just believe Detective Shepard. Everything he says is corroborated by evidence. And Miss Cassandra Salloway, what did she tell you? She identified that muzzle flash as that defendant is standing in the middle of that street, firing off. And what did she tell you? The jeans are so light, they blend into the street. Who is the only person out there with light jeans on? Because everybody else is smart enough to wear all black, except for the defendant. So even their witness has identified the defendant as being the shooter out there. Black do-rag, his twist, his light skin, his red t-shirt, his light jeans that we know belong to him because he had them on in another picture with another gun, his black bag, his black shoes, and his gait. What did Detective Shepard tell you? The way he was walking, and y'all saw he's kind of walking kind of funny because of that gun. It's messing up the way that he walks. So that's how he's able to follow him from the BP, from the package store to behind the barricades. Every step he's making is distinct. He decided he wanted to be seen because I'm going to rep my gang. I'm going to put on my gang t-shirt, Pyro, Elm Street, Pyro, whoop on the back. I want to be seen. And he was seen by each and every one of those cameras out there. And he was seen shooting at that car and killing that baby. Don't leave your common sense, ladies, at the door. You've watched the videos over and over again. Believe what your own eyes tell you. Miss Young, if you talking this, trust the videos. You've seen them enough. If you want to see them again, you can. I think Mr. Body said it out. We didn't even coordinate on this. Context clues. Those are important. I had a son, he was real younger, and I said a word, and I said, how do you, and he said, oh, that means such and such. And I'm like, how do you know that? He said context clues. Ladies and gentlemen, use your context clues when you get back there. Red shirt, white lettering, light jeans, black satchel, AR-15, funky little walk because of your AR-15, your light skins, your twist, and who you come up with. At 9:45:21, this defendant is standing at his post. Light jeans, red shirt, black shoes, black satchel, light jeans, red shirt. You can kind of see that AR hanging down right here. Black shoes. At 9:45:21. At 9:46:02, less than a minute, that Jeep is pulling through. He has not moved. You saw the videos. At no point does he leave from those barricades. The only time he leaves from those barricades is when he steps to that Jeep as it pulls through. And here he is again. AR extended. How do you know it's him? Them light jeans, them dark shoes, You can kind of see it here in red, but it's dark because if you all know when you take pictures, if the lighting is behind you, it's going to be dark. That's why kids always tell me, get the light, you got to get the light so you can make sure your colors pop. But it's enough for us to see it ain't. If it ain't in black, ain't the man in black, ain't the man right here. Light jeans, dark shirt, AR. And what did Samantha McCord tell you? If you point a gun, you ready to shoot a gun. Not less than 5 minutes later. I hope when we don't go through the timeline, this is what he's doing. Pointing his gun. And when that car comes through, 2 to 3 minutes later, he is ready to shoot, and that's exactly what he does. And I know it's blurry, ladies and gentlemen, but I hope you can see it enough. That's him. Look back. Now, where are these other men? They're back here. Where's the Jeep? Tracking his every step. That's him, ladies and gentlemen. Now, when Mr. Rayshard got up here and showed you this video, he didn't want to zoom in this close. Because if you zoom in this close, you get to see his client committing this murder. Physical evidence in this case, ladies and gentlemen, because we're not just going to bring you the witnesses, we're not just bringing you the video. Does the physical evidence show that this defendant is guilty? And we talked about these videotapes from every angle, not just one angle, not just a half an angle, every angle, tracking him so you don't have to wonder, is it him? Did he go somewhere else? There is no doubt it is him each and every time. Nine 12:45. Nine 13. 9:13, 50 seconds. 9:15. Directing the marshal, telling him where he can go. $9:38. Back at his post. Moving the cones. Moving in on the McCords because they have challenged his authority. $9:40. Every minute, every second. The defendant is present and making decisions as he's terrorizing and victimizing people in their community. I hope y'all see Mr. King go that way, and he goes. 9:40. $9:45, 24 seconds. Just seconds before that Jeep comes through. You can't miss him, white lettering. One shot, two shots. And we show y'all, it's another man in all black shooting. We're not trying to hide from it. Because it doesn't matter. Everybody at that barricade is responsible for Secoria's death as a party to the crime. What's the physical evidence? Defendant there before, during, and after the shooting. What's the path of those bullets in that car? All on the driver's side. Now, Mr. Raby started to talk about path and trajectory and when they have to come from the right. None of it makes sense because all of the defects are on the right side of their car. The muzzle flashes that you see coming from that defendant's gun, when the police get out there and they find shell casings right there in the area where he was seeing it, where he was firing his shots. 6 shell casings, 7 of them. How many defects in that car? 8. And we saw the pickup man coming by picking them up. So maybe he was lucky enough to get one of those shell casings that came from the defendant's gun. Driver, door, back, driver, passenger side door, bottom of that passenger door, the side panel. So we know that the shots came into that car from the left. That's what the physical evidence tells you. And then those last two, and I will submit to you, ladies and gentlemen, that last fatal shot came through marker number 8. This is the passenger side, and you'll have the pictures back there that you can look at. They tried to say, oh, well, isn't that maybe some bullet holes? It's dirt, ladies and gentlemen. Through that back trunk, through the back panel of that door, of that seat, through the seat, into Secoria's back.
Objection, Your Honor. May we approach?
Yes. Okay. We've just stopped because part of the video creation was starting to show. There was an immediate objection. Objection is, go ahead.
Ron, that's evidence that is not going to come. That's demonstrative that we have never seen before. We have never vetted. Perhaps we should have kept our expert. We've not had our expert look at it to gauge whether it's representative of anything. It's just something that, again, that we have never seen this demonstrative, and we've had no opportunity to vet it, to check for any scientific accuracy, or to see if it's even representative of anything, to determine whether the jury should see that. So as it is right now, the jury is seeing a piece of evidence, because that's what it is, evidence that has never been shown to us before. We move for a mistrial, Your Honor. We can't undo it. The jury saw it. The jury saw the representation, the 3D animation. It's improper.
Okay, let's see. First of all, can we look at what it was? And I'll say that we saw just the very, very initial beginning of this, so.
We didn't see the very beginning of the jury saw the whole thing move. Like, while we were talking.
While we were talking it,
While we were walking up there, it was still moving.
okay. Okay, so to narrate that video, we saw what I guess is your theory of how this happened?
Absolutely, Your Honor. It's just a reenactment. There's no less than bringing a car and putting a car right there and having it on wheels and being able to move and walk alongside of it and maybe with a paint gun shoot at it to hit the doors and the areas in the trunk and the area that the state's evidence indicates where those bullets went into the car. There's no measurements on there. There's no trajectory information. It is just a reenactment of the video that you see as the defendant walks up to the car and it's moved. The car is moving because Mr. Regis, in his demonstrations that he did during trial, wanted to make it appear that the car just was staying stationary. It wasn't moving, and therefore his client could be at the back of the car. This is the state's theory how his client ended up at the back of the car, and those shots ended up in the back of that trunk and then into that baby.
New evidence. I'm sorry. It's new evidence. We've not had an opportunity to object to it, to question the creator of it, to do anything that we would need to do. And we have a case. I don't have a case yet.
Yes, Your Honor. The case of Rickman v. State, that's 304 Georgia 61, the 2018, I'm sorry, 304 Georgia 61, the June 18, 2018 case.
What's the name of it again?
Rickman, R-I-C-K-M-A-N v. State. Demonstrative evidence, which includes reenactments and pictures used to aid the trier of fact in understanding the issues of fact at trial, is irrelevant and inadmissible unless accompanied by a witness testimony that shows the demonstrative evidence is substantially similar to the actual conditions or events at issue.
It's not an evidence, Sean. It's part of my closing argument.
You can't even use the closing arguments if you haven't to put it in as evidence. The point is, there's a process to how to use demonstrative evidence. If the state literally jumped over and skipped the process, and now they're throwing it in front of a jury to say, this is what happened. These are the facts based off of our testimony. That is not how demonstrative evidence is supposed to work.
It is not demonstrative evidence.
Okay, do you,
Hold it back yourself.
okay, hang on for a second, stop fighting. I'm going to read the case. Do you think that if before closing arguments she had shown it to you and given you a chance to object, that might have been used? Or is your position it had to be evidence in the trial?
It should have been evidence in the trial, but at a minimum, it should have been shown to us before closing to give us an opportunity to object to it being placed before that jury. And we haven't had that opportunity. And we would have objected, but we just haven't had that opportunity to do that now because they sprung it on the jury without ever giving us any opportunity for a meaningful examination of it.
Okay, let me read the case.
And Ron, can you make certain you read the coordinates?
Yes. Yeah, if anybody needs to take a break, that's fine.
Which point are you looking at? They're like 6 bullets.
2, probably. Looks like what he's talking about.
Actually, yes, if you hit 2 and go down to the middle of the case itself, that's what the language is.
Is it 306 Georgia 61?
304 Georgia 61, 2018 case, Rickman v. State. Inside right, 464.
Okay, I'm going to step off the bench for just a second because I'm only getting part of the case.
What's that? You in contested yet?
Yeah, you noticed.
I thought that.
I think the TV's going bad. I think the TV's going bad.
You did the deal laptop charge. That's what I have no problem. I have no problem. Did y'all make the borrow a power cable or something? Because we don't want to.
If you need to borrow, yeah, if you got to borrow,
Oh, wait, no. So, so you just So this is just power that y'all just trying to get these young guys.
It has power, it's all plugged into the back.
Well, this wouldn't cause this.
That's what I'm saying.
TV must just.
We've been doing it all week. We've been doing it all week. And then all
It
this
might
stuff work.
yeah, video cable or.
You're an IT person. Oh, you were that. I know
Let me do the math. Oh, it was, yeah. 115. It was definitely 150. Okay, and then 208 is when you started. So let's say 3 minutes each. That would leave. More than that, I think she's okay. Okay, first things first, I want to make sure that we don't steal time from your closing because we stopped repeatedly. It looks to the court like you have about 11 minutes left. Anybody disagree with that? Looks to me like she's got about 11 minutes left. From when we cut off before the, okay. Around 11 minutes too, okay. So that case was close but not quite, and I'm glad you brought it to the court's attention. It's good information. I think under different circumstances in this situation, if the rendering had just been showed to the defense, the court may have admitted it over the defense's objection with proper instruction to the jury. But because it was not offered prior and we didn't have that discussion, I think out of an abundance of caution, we're not going to play it for the jury. I'm going to just give this instruction and you'll be allowed to just continue your argument. A computer rendering of the state's theory of how events in this case might have occurred was played several minutes ago. This was not evidence in this case and was merely an illustration of the state's theory of the case. You are not to consider this computer rendering as evidence in this case. The arguments of the attorneys are not evidence. You are to base your deliberations and decision in this case on the evidence that was admitted in trial only. Anything else that you would like me to say?
I think it is, with all due respect, I'm sorry, I think it was way too generous to the state. I believe it's improper. Earlier, when Detective Shepard said some things that were improper, the court inserted the word improper into its instruction to the jury. I think the jury should be told that that was improper. And secondly, what I will characterize as what lawyers say is not evidence. I'm lumped into that bag with them. They did something that was improper, and I don't know that we need to do a both sides thing in terms of what lawyers say, in terms of what all of us say is not evidence. That is factual, but the situation that compels this instruction is something the state did, and I think the jury should be told what the state did, again, was improper, and disregard that and place no weight on it.
And I don't believe it's improper for the state to be able to argue our theory of the case and what occurred out of it. So calling it improper, I don't think is a fair statement of what the state has done. We are allowed to illustrate what we believe. It's argument, and they can decide, I don't believe that's how them shots got into the car, or I do believe it. It's up to them to do that. For me, illustrating it is no less than, like I said, me wheeling a car, I'm sorry.
You're okay.
And pointing at it right here in open court. That's nothing that I would be able to put before Mr. Reyes and Mr. Weaver prior to it starting, and there's nothing that prevents us from doing it because it does not have to be entered into evidence because it is not evidence. It is the state's argument, it is the state's theory of the case.
And if I recall, I saw the word evidence at some point under the, I don't know if it was under the heading of physical evidence, but it was under the state's own heading of this is evidence.
There was no heading on that slide, Your Honor.
Perhaps not that slide, but it was billed as whatever the case may be.
Well, they can have a heading on a slide that lists the evidence that says evidence.
But that should not have been listed as evidence at the point I'm making, Your Honor.
And it was not, Your Honor. The slide had no heading at all.
Okay.
And it's not even illustrative of the state's theory. Detective Shepard said the shooter was stationary. That was a graphic showing a moving shooter. So it wasn't shown to us, and it's inconsistent with their star witnesses' testimony as to what occurred.
Okay.
It's wrong on a lot of levels.
Well, it's not wrong on the video because he's shown moving on the video, Your Honor.
Okay, I understand everyone's frustration. This is a situation that could have been handled prior to closing arguments. So, so I'm going to go ahead and give an instruction on this, and motion for mistrial was denied. Anything else that you want to put on the record?
No, Your Honor.
Okay.
I would actually like the instruction read once the jury comes back in with any dangerous charges as well. I think because of how inflammatory what the state just did is, I think they need to hear it more than one time, Your Honor.
Okay.
Isn't part of the pattern charge that nothing?
Part of the pattern charge, there's extensive information in the pattern charge about attorneys' comments not being evidence. Okay, we can take that up after we finish closing. We're ready.
Are you going to read it within, is that the instruction, or have you changed it, have you modified it? I'd like to hear the instruction the court is going to give, if I may, Your Honor.
That's fine. Yeah, I think I've said you are not to consider this computer rendering as evidence in the case. I am happy to make it you are not to consider this computer rendering, if that is closer to what you were hoping I would say. I'm not going to say that it was improper. I think under other circumstances that video could have come in.
Under the right process.
Under the right process.
That's the issue.
Well, and yeah, it's hard. There's not rules of evidence about how to do that. Okay. We're ready for him. Okay, remember you got 11 minutes left. You had 14? Sorry. Let's see, what does Madam Court Reporter have?
He waved back, Your Honor.
She started off with an hour and 6 minutes. She started off with an hour and 6 minutes left.
All right, the jury. Judge, that kind of court.
Okay, members of the jury, we're about to resume closing arguments. I need to give you this quick instruction. I'm sorry, I'm not looking at you. I need to speak into the microphone for you. A computer rendering of the state's theory of how events in this case might have occurred was played several minutes ago before the break. This was not evidence in the case and was merely an illustration of the state's theory of the case. You are not to consider this computer rendering. The arguments of the attorneys are not evidence. You are to base your deliberations and decision in this case on the evidence that was admitted in trial only. Okay, you can resume your argument.
Thank you, Your Honor. Ladies and gentlemen, I hope you remember in the video where you can see the defendant step up and move along the left side of that car, firing shots into it, and then the evidence indicates there are 8 shots in it, following that pattern that the defendant took as that truck passed by. Then you have the shell casings that you saw from the crime scene tech. Each and every one of them that landed there, that's on that side where that Jeep passed by, 556, 556, and what did Ms. Van Home tell you? That's consistent with being fired from the AR-15. 8 shots, 7 shell casings, 7 of them are 556s, all shot from the same weapon, right in the area where this incident occurred. And there was some rumbling about shooting from the car, but there's no evidence. Mr. Reagan's talked about humidity and all of that stuff, but there's no evidence of that. The only evidence is that this defendant walked up to that car and fired off 8 rounds into that car and then caused the death of Secoriea Turner. And we talked about the man in the black walking down the yellow, well, all the way to the barricade. He's furthest away. So we know, that's the safe theory, that that is not the bullet that went into the back of the car and killed Secoriea. The next guy that's in all black, he's walking along the yellow line, and what's found where he is, a .38 projectile. And then there's none at that back barricade, so we know nobody back there was shooting. We know the only person that was shooting, where these muzzle shots are coming out, is the defendant with his light pants on and his dark shirt and that muzzle flash coming out of his gun, while these three people stand back here doing nothing. The scientific evidence, the way that it goes through the back trunk, through the back of the seat, through the outside of the seat, into Secoriea. And like I said, they failed to mention that, so I'm not going to waste my time on it because they know it was foolish too. 5.56 shell casings, 5.56 projectile, type of weapon that can fire, 5.56 AR-15. The only thing we ain't got to give you is the AR-15, because what did Ms. Van Hoen tell you? I can look at it, and I can test against the weapon, and I can determine that whether or not it is a murder weapon, or I can eliminate it. If I had it for you, I would give it to you, but I don't. The medical examiner. And I know it was hard looking at these pictures, ladies and gentlemen. I've been doing this a long time, and it's difficult each and every time, because nobody should have to look at a baby laid out on the table with a gaping bullet wound in the back of her. But the only person that is responsible for causing that wound back there sits right there. That's on him. Went through her body with so much pressure and so much force, it starts to break apart. We have everything but that gun to be able to tell you this is exactly the gun that did it, because we know all of those 5.56 shell casings came from the exact same weapon. Don't believe me, don't believe the videos, don't believe the physical evidence, don't believe the science if you don't want to, ladies. Just believe him. My grandmother always told me, when somebody tell you who they are, believe them. When they show you who they are, believe them. And this defendant has shown us who he is and what he is capable of over and over again. Cobb County with his red bandana, his gang tattoos, his gang language, burn it down. ARs everywhere, every photograph you got with his AR. Pointing it at people, terrorizing people, allowing a community to be locked down because he decided, I'm claiming this as my gang territory. And when he shoots that baby, where he go? Over on edge with his AR-15, still dangling between his legs. But when he shows up to say, oh, that's me, what's conveniently gone? One of those distinctive markers, those twists. He's trying to change, he's trying to hide. But ladies and gentlemen, y'all tell him he cannot hide. He is no longer in the shadows. You see him clearly as who he is. He may sit over there with a suit on, with his haircut, looking nice, but that's not who he is. He is a killer. We saw that in his video at the jail. August 5th, 2025. Just days before this started. This is what he's doing. What is his words? I empower.
Don't play with him. Yo.
If I tell you, if I show you, believe it. This is who I am. What he got on him? His gun. Because where he don't go, we don't link up without our sticks. He tells you I had an AR-15. He tells you I was at the barricade. If he don't, even though he don't tell you he shoot, I told you, party of a crime, he is just as guilty. But we know that that is a lie. He shot 8 times into that vehicle. But see, he didn't know the story. He didn't know that Detective Shepard had those videos. He thought I could step out and say, oh, it was me. He didn't realize it. So what did he do? He lied. Mr. Ravis want to talk about lies? That's what that defendant has done. He lied. He got up there. Somebody was hit. Y'all seen that video. Not one person was hit. Not one person hit the ground and jumped up and started shooting. A lie. He said he wasn't shooting. Muzzle shot after muzzle shot. He lied to his attorney because Jackie Patterson only repeated what the defendant told him because he wasn't out there. He hadn't seen no videos. He's a liar and a killer. That's what his autobiography tells you. And what does he say? After he sees this, I'm going down the road, I ain't shooting. I ain't even have a gun. Lies. What did he say when they posted the bolo on McKinney? I was out there, bro. Bro ain't even shooting. He's talking about McKinney. Every man out there was shooting at the car. He the only end that walked to the store. It happened at the burnt down Wendy's. Everybody was shooting but McKinney. That included him. He told y'all he was shooting because everybody out there was shooting. But he's the one that shot and killed Secoriea Turner. Every piece of evidence the state has brought points to this defendant's guilt. The law, the eyewitnesses, the physical evidence, the scientific evidence, the defendant's own actions, and ladies and gentlemen, I implore you to use your common sense, and when you use your common sense, it leads to no other road than the defendant's guilt. Now, we've talked about him for days now. This case is about Secoriea Turner, 8 years old, just riding in the backseat of the car with her mom, coming from celebrating the 4th of July, having fun with her family, her friends, playing with her cousins, watching fireworks for the night. She was having so much fun. What did her mom tell you? She didn't want it to end. I want to go hang out with my cousins. And her mom was trying to make that happen as they headed down University. Nobody knew that day that that was going to be the last time that Charmaine got to go to the nail shop with her baby. That was going to be the last time that Secoriea got to go to a barbecue and a cookout with her grandmother and her cousins. That was going to be the last time that she got to play with fireworks. That was going to be the last time she got to call to play with TikTok, because we know that's what she liked to do, make her TikTok videos, and that's what she was doing back then. And nobody knew it was going to be the last time that she got to call out her mother's name. 8 years old. It is not fair. It is senseless, and it is unnecessary. But the defendant wanted to stake his claim. 4th of July is supposed to be about celebrating with your family. For Secoriea Turner's family, forever now. 4th of July is not about celebrating. It's about grief, and it's about mourning. This coming November, Secoriea would have turned 13 years old. A milestone for young kids, especially little girls. She will never get to reach that milestone. Mr. Regis told you that the defendant was making dumb decisions because he was 19. Secoriea will never have an opportunity to make dumb decisions as teenagers do. Her mom told you how she wanted to go to Spelman, and Mr. Regis told you how his girls got to go to their HBCU. Secoriea will never get to go to Spelman because of this defendant. Hopefully one young girl will get to go because they have a scholarship in her name. Now, Mr. Regis talked about Ahmaud Arbery. I am from Brunswick, Georgia. I live one neighborhood over from the neighborhood where Ahmaud was killed. I went to church with his aunts. So I know what it feels like to have someone in your community taken because of senseless violence. In his honor, they do a 2.23 mile run because those are the last miles that he got to run that day. For George Floyd, they have a moment of silence for him. 8 minutes and 46 seconds, because those were the last minutes of his life. At some point, hopefully, not just a scholarship, but maybe 8 minutes of silence for Secoriea for the 8 years of her life, or the 8 bullets that flew into that car and took her life. That's what we can do for her in the future. But today is a day that you can give this family the justice that they finally deserve. Mr. Regis talks about 9 days, a rush to judgment, a rush to judgment. I tell you, ladies and gentlemen, it has been a slow crawl to justice for Secoriea and her family. They have waited 5 long years, 1 month and 22 days. I ask that you don't make them wait 1 more day, 1 more hour, 1 more minute. Tell this defendant what he already knew when he stood up at that press conference. He is guilty, guilty, guilty of each and every charge on that indictment. Thank you.
Okay, members of the jury. My instruction to you is going to take about 45 minutes. Would you like to eat before you give the instructions? Okay. We ordered food for you, so you can just go to the back and have that. Just make sure that you don't discuss the case amongst yourselves. Don't do any research. Don't look at your phones. Don't talk about the closing arguments. Just eat lunch, and then we'll come back and have the charge.
All right, so the jury.
You can eat quick? Okay, that's fine. You let us know. We're at your beck and call. You think about 15 minutes? Okay. And proves the guilt of the accused beyond a reasonable doubt. The jury must determine the credibility of the witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. The credibility of a witness may be attacked by disproving the facts to which the witness testified. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. In determining the credibility of a witness, you may consider, where applicable, evidence offered to attack or challenge the witness's credibility. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. A defendant in a criminal case may take the stand and testify, and be examined and cross-examined as any other witness. However, no defendant has to present any evidence nor testify. If a defendant chooses not to testify, you may not consider that in any way in making your decision. Identity is a question of fact for you to determine. Your determination of identity is dependent upon the credibility of the witness or witnesses offered for this purpose. You should consider all of the factors previously charged to you regarding the credibility of witnesses. Some, but not all of the factors you may consider in assessing reliability of identification are: the opportunity of the witness to view the alleged perpetrator at the time of the alleged incident, the witness's degree of attention toward the alleged perpetrator at the time of the alleged incident, the possibility of mistaken identity, whether the witness's identification may have been influenced by factors other than the view that the witness claimed to have, whether the witness on any prior occasion did not identify the defendant in this case as the alleged perpetrator, and the length of time between the crime and the out-of-court identification. It is for you to say whether, under the evidence in this case, the testimony of the witnesses, and the facts and circumstances of the case sufficiently identify this defendant beyond a reasonable doubt as the perpetrator of the alleged crime, or that the defendant was a party to it. It is not necessary that the defendant show that another person committed the alleged offense. If you do not believe that the defendant has been sufficiently identified as the person who committed the alleged crime or was a party to it, or if you have any reasonable doubt about such, then it would be your duty to acquit the defendant. The burden of proof rests upon the state to prove beyond a reasonable doubt the identity of this defendant as the person who committed the crime alleged in this bill of indictment. This defendant is charged with crimes against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act and an intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but means simply the intention to commit the act that is prohibited by a statute. This defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every party to a crime may be charged with and convicted of commission of the crime. A person is a party to a crime only if that person directly commits the crime, intentionally helps in the commission of the crime, intentionally advises, encourages, hires, counsels, or procures another to commit the crime, or intentionally causes some other person to commit the crime under such circumstances that the other person is not guilty of any crime either in fact or because of legal incapacity. Any party to a crime who did not directly commit the crime may be prosecuted for the commission of the crime upon proof that the crime was committed and that the person was a party to it, even though the person alleged to have directly committed the crime has not been prosecuted or convicted, has been convicted of a different crime or degree of crime, is not amenable to justice, or has been acquitted. Knowledge on the part of the defendant that the crimes charged in the indictment were being committed and that the defendant knowingly and intentionally participated in or helped in the commission of such crimes must be proved by the state beyond a reasonable doubt. If you find from the evidence in this case that the defendant had no knowledge that a crime was being committed or that the defendant did not knowingly and intentionally commit, participate, or help in the commission of and was not a conspirator in the alleged offenses, then it would be your duty to acquit the defendant. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crimes charged in the indictment were being committed and that the defendant knowingly and intentionally participated or helped in the commission of them, then you would be authorized to convict the defendant. A jury is not authorized to find a person who was merely present at the scene of a commission of a crime at the time of its perpetration guilty of, consent in, and concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in the actual perpetration of the crime, or participated in the criminal endeavor. A jury is not authorized to find a person who was merely associated with other persons involved in the commission of a crime guilty of consent in or concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person helped in the actual perpetration of the crime or participated in the criminal endeavor. The law provides that criminal action shall be tried in the county in which the crime was committed. In a prosecution in any case in which it cannot be determined in what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. Venue, that is, that the crime was committed in Fulton County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offenses. Venue must be proved by direct, circumstantial evidence, or both. The defendant is charged in count 1 with murder. For malice murder, the state must prove that the defendant caused the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be a significant provocation, and all of the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or killing and it moved the defendant to do it, that is enough for the killing to be murder. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. The defendant is charged in counts 2 and 3 with felony murder. For felony murder, the state must prove that the defendant caused the death of another person by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Aggravated assault with a deadly weapon and criminal damage to property in the first degree are both felonies, which I will define for you shortly. You may find the defendant guilty of felony murder as alleged in count 2 if you believe that he caused the death of another person by committing the felony of aggravated assault with a deadly weapon, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. You may find the defendant guilty of felony murder as alleged in count 3 if you believe that he caused the death of another person by committing the felony of criminal damage to property in the first degree, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. The defendant is charged in counts 4, 5, 6, 13, and 14 with aggravated assault with a deadly weapon. For aggravated assault, the state must prove that the defendant assaulted another person with a deadly weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. The defendant is charged in count 7 with criminal damage to property in the first degree. For criminal damage to property in the first degree, the state must prove that the defendant, knowingly and without authority, interfered with any property so as to endanger human life. The defendant is charged in counts 8 and 15 with possession of a firearm during the commission of a felony. For possession of a firearm during the commission of a felony, the state must prove that the defendant had a firearm on his person or within arm's reach of his person while committing a felony, which is a crime against or involving another person. Murder, felony murder, aggravated assault with a deadly weapon, and criminal damage to property in the first degree are referenced in count 8. Each of those offenses are felonies which have been and have been defined in this charge. Aggravated assault with a deadly weapon is referenced in count 15. That offense is a felony and has been defined in this charge. For purposes of this offense, a firearm includes any handgun or rifle. The defendant is charged in counts 9, 10, 11, 12, 17, 18, 19, and 20 with the offense of violation of the Street Gang, Terrorism, and Prevention Act, also referred to as the Gang Act. For a violation of Subpart A of the Gang Act as alleged in counts 9 and 17, the state must prove that there is a criminal street gang, that the defendant is associated with that criminal street gang, that the defendant participated in criminal gang activity, and that there was a nexus between the crime that was committed and the gang, i.e., that the crime was committed to further the interests of the gang. For violation of subsection B of the Gang Act as alleged in counts 10 and 18, the state must prove that there is a criminal street gang, and that the defendant is associated with that criminal street gang, that the defendant participated in criminal gang activity, and that the defendant committed criminal street gang activity with the intent to maintain or increase his status within the criminal street gang. For violation of subsection E of the Gang Act as alleged in counts 11, 12, 19, and 20, the state must prove that there is a criminal street gang, that the defendant encouraged another to participate in criminal gang activity, and that the defendant was at the time an associate of that criminal street gang. For purposes of the Gang Act, the term participate can, but does not have to be defined as, to take part in something and or to share in something. Criminal street gang means any organization, association, or group of 3 or more persons associated in fact, whether formal or informal, which engages in criminal gang activity. The term criminal street gang shall not include 3 or more persons associated in fact, whether formal or informal, who are not engaged in criminal gang activity. The existence of a criminal street gang may be established by evidence of a common name or common identifying signs, symbols, tattoos, graffiti, or attire, or other distinguishing characteristics, including, but not limited to, common activities, customs, or behaviors. Whether a criminal street gang exists in this case is for you, the jury, to decide. Criminal gang activity means, among other things not relevant to this case, the commission, attempted commission, conspiracy to commit, or solicitation, coercion, or intimidation of another person to commit any criminal offense that involves violence, possession of a weapon, or use of a weapon. For purposes of the counts charging a violation of the Gang Act, murder, felony murder, aggravated assault with a deadly weapon, criminal damage to property, and possession of a firearm during the commission of a felony constitute criminal gang activity. The commission of any offense that would constitute criminal gang activity by any member or associate of an alleged criminal gang may be considered by you to determine whether the state has proven beyond a reasonable doubt the existence of the criminal street gang and criminal gang activity. Presence, companionship, and conduct before and after the commission of the alleged offense may be considered by you in determining whether or not such circumstances, if any, give rise to an inference of the existence of a conspiracy. A conspiracy is an agreement between 2 or more persons to do an unlawful act, and the existence of a conspiracy may be established by proof of acts and conduct, as well as by proof of an express agreement. When persons associate themselves in an unlawful enterprise, any act done by the party to the conspiracy to further the unlawful enterprise is considered to be the act of all the co-conspirators. However, each person is responsible for the acts of others only insofar as such acts are naturally or necessarily done to further the conspiracy. Whether or not a conspiracy existed in this case is a matter solely for you to determine. The verdict form lists all of the counts and offenses you will be considering. You will consider each offense listed. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Fulton County, Georgia, did on or about the date alleged commit an offense or offenses charged as alleged, you would be authorized to find the defendant guilty of such offense or offenses. In that event, the form of your verdict for such offense or offenses would be, we, the jury, find the defendant guilty, and you should place an X or a check mark on the blank next to the word guilty for any such offense or offenses. If you do not believe that the defendant is guilty of an offense or offenses, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant on that count or those counts. In that event, the form of your verdict would be, we, the jury, find the defendant not guilty, and you should place an X or check mark on the blank next to the word not guilty for any such offense or offenses. One of your first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind, talk with each other, and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Don't hesitate to change an opinion if you are convinced that it is wrong. However, you should never give up an honest opinion to be congenial or to reach a verdict solely because of the opinions of other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are also not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. These rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, or social media of any kind. Whatever your verdict is, it must be unanimous. That is, agreed to by all. The verdict must be in writing and signed by one of your members as foreperson, dated and returned to be published in open court. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, or economic status for or against either party. By no ruling or comment that the court has made during the progress of this trial has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. You are only concerned with whether the defendant is guilty or not guilty. You are not to concern yourselves with punishment. There are 2 alternate jurors, and we can only allow 12 to deliberate the case. The deputies will show the alternate jurors to a separate location. That's jurors 33 and 35. You may now retire to the jury room. You may elect a foreperson, but do not begin your deliberations until you receive the indictment and any evidence that has been admitted in the case. Any jury communication to the court must be in writing, signed by the foreperson, so that means questions. Now, I know that you've requested to actually perform your deliberations in a different location, and that's fine, but if you want to see evidence that you don't receive in the back, which will be much of the evidence, you're going to have to come back down here to see it. So just so you know that, in open court. If you have any questions or you want to request evidence, you just send us a note and have your foreperson sign it. All right, will you go ahead and step out?
All right, to the jury.
Okay. Do you guys want to take a look at whether you agree on what goes back?
Yes, Your Honor, but before we go forward, on behalf of Mr. Conley, we'd like to renew all objections that have been raised last week.
Okay. And just let me know if I need to break a tie on something. Otherwise, if you agree, it'll go back.